I know a lot of law students get a great deal out of the judges among us that that live stream a lot of our proceedings, because they're able to just go back and look at it and learn. And just like in the old days when they would sit in the courtroom, now I still encourage them to come sit in the courtroom.
Sure.
But sometimes it's, not nearly as it's not nearly as easy to do with as much as they all have going on these days.
Well, I am certainly appreciative of the judges that are willing to hold some of the longer calendars but shorter hearings on Zoom. It's just such a huge time saver.
Well, when we started doing that, because as I think I've mentioned, I was a civil litigator like you guys were for my career. And so when we started doing Zoom calendars, I was like, oh, we're never going back for civil. And even criminal, I will, if a lawyer can't be there, and they can't make a simple announcement, then I have to move that case by a whole day or by a whole month sometimes for the calendar. And so, letting a lawyer jump on Zoom from DeKalb County Courthouse where they're waiting on a trial calendar just to say my client pleads not guilty and waives arraignment,
right.
It makes my life so much easier. And the lawyers, there is definitely that, missing out on the glad handing and getting to know you and let's go in the hallway and see if we can work this out. But I know the lawyers are able to be much more efficient and get a lot more done when they're sitting at their desk while they're waiting on me to deal with something else and can actually do work. So.
Matthew, are you able to hear us, and can you unmute, just make sure we can hear you?
Yep. Is this working? Can you hear me okay? Good morning, everyone. Sorry. And there's no feedback from my speaker, is there?
Yeah, no, sir. Mr. Gunbie, can you hear me? This is Judge Krause.
I can hear you, Your Honor, very clearly.
So
I can hear you.
Right. One of the reasons that I've realized now what you were talking about is that all the sound in the courtroom is pegged to the podium. And so what happens is when I talk, it activates the podium because that's where the sound's coming from. Okay. Now I'm on his screen, so he can see me, but it's me and multiple other boxes.
Right, and he can probably pin you or, however you set your vision settings or your view settings. Okay. But Matthew, you can see the judge, correct?
No, I don't think I can. I have a box that says staff attorney, Mitchell somebody, and
there should be another box.
Right. So if you check your settings, Mr. Gunbie,
yes, I've got it. Sorry, you're there.
There should be
seeing you.
So you can see it. Excellent.
Yes, I've got you.
Okay.
May I apologize in advance?
Experiencing
last night, the Wi-Fi worked well. I did have a blip once, but I hope that the Saudi wireless network will be good to me this afternoon.
Okay. So I'm going to warn y'all about something that y'all just experienced firsthand. It happens all the time. The system works very well in a lot of ways, but one thing that sometimes is a problem is that people that are remote, when we're doing a hybrid, right, where we're all here, but someone is remote, if we were all just on Zoom, we wouldn't have any problem hearing each other, but sometimes there's a delay. And so I suspect that you'll need to account for a little bit of a delay for yourself. When you ask a question, when Mr. Gunbie is speaking, give him a minute to finish. Otherwise, we're going to be talking over each other. But other than that, I think we've got the logistics mostly worked out. And the only thing, unless y'all have any preliminary matters, Mr. Downs?
No, none of mine.
Okay.
No, Your Honor, just one question. Would the court prefer that I stand at the podium to examine Mr. Gunbie, or can
I have no preference. It makes sense for me for you to sit. I was just saying, turn your own screen on so he can see you. Your screen is not currently on. You just have your nice picture there.
Oh, I see.
Yeah.
Okay.
Madam Court Reporter, we are going to officially go on the record now.
I just had one comment.
Sure.
But
you are on.
Yes. I realized yesterday. There are certain courtrooms that have the audio feedback noise, and this is unfortunately one of them.
Okay.
And there's nothing I can do really, so I just have to utilize my backups.
Okay.
I can hear still, and it's like you can hear, but there's like a static noise that's just throughout the entire audio.
Is it in your recording?
Yes.
Okay.
And it's because of the courtroom. I've already tried to unplug it and then.
Complained about it multiple times, don't worry.
Yeah, we've came and we're aware of it, there's just nothing we can do, so we
Mhm.
just utilize the backups, but because of that, I just wanna say, like, if I interrupt, I just wanna make sure I hear Mr. Gunbie really loud and clear.
Understood. I appreciate it.
I mean, I can hear it pretty well here, and it's picking up, so I'm just like, but if I do interrupt, just if he needs to repeat or.
No, I understand. Thank you.
Okay, thank you.
Okay, so Madam Court Reporter, we are going to go on the record day 2 of the trial of Keith Badham and Liliana Del Rio Badham versus Matthew and Yvette Gunbie, case number 25 CV 009445. I'll note for the record that all the parties are here in the courtroom, and I don't believe there were. I think where we left off was whether there were any preliminary matters we needed to take up before the defense called its first witness. Mr. Withers?
No, Your Honor, no preliminary matters.
Okay. So Mr. Withers, if you, the defense would like to call its first witness?
Yes, Your Honor, we call Matthew Gunbie.
Okay. Mr. Gunbie, will you please raise your right hand? Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir. You may lower your hand. Go ahead, Mr. Withers.
All right. Good morning, Mr. Gunbie. Let's start out telling the court a little bit about yourself. Tell the court, what do you do for a living?
I am a management consultant with a background in finance and accounting.
Okay, and who do you currently work for?
I work for myself with my own business.
And where is that business based?
Currently, I'm working in Saudi Arabia with a client here, where I've been for the last few months.
And just what time is it where you are right now, just to kind of get a sense?
It's 4:20 in the afternoon.
Tell the court about your educational background, if you would.
Yes, I went to Southampton University in the United Kingdom, where I obtained a Bachelor of Science Joint Honours in Economics and Politics, and went through secondary school education in the UK as well. From a professional career perspective, I'm a qualified chartered accountant in the Institute of Chartered Accountants in England and Wales. I am also a CPA in the state of Georgia.
And have you ever worked as an accountant?
Yes, I was a partner with PricewaterhouseCoopers, based in Atlanta until 2008, and then subsequently I was a partner with Ernst & Young here in the Middle East.
And so, kind of given your background and the fact that this case involves a lot of spreadsheets and numbers and so forth, do you feel like you have a competent understanding of financial documents, ledgers, spreadsheets, documents of that nature?
Yes, I do.
Okay. And you are obviously married. How long have you been married?
We've been married for 40 years this year.
And how many children do you have?
We have 4 sons.
And how old are they?
We have twins who are 33. Let me get that right, 33. A son who's 31, and we have another son who's 29.
And how long, well, let me ask this. How did you come to the United States, or when did you come to the United States?
We moved to the United States in 1992. I transferred with what was then Coopers & Lybrand from the UK over to the Atlanta office of Coopers & Lybrand, which subsequently became PwC in 1999, following our merger with PW. So my intention was to move back to London after 2 years, but we ended up falling in love with Atlanta, and we still there, and I made partner in 99 and stayed with the firm there.
And where do you currently reside?
My residence is both here in Bahrain and obviously back in Atlanta.
And in Atlanta, it's at 6365 Colwood Court, correct?
Yes.
Tell the court how you came to meet and become friends with Mr. Badham.
Yes, Keith and I met in, I think it was either late 2001 or I think early 2002. It was not long after the Twin Towers attack, and Keith had moved over. And I think the first time we met actually was a British American business group lunch meeting. I think the British British ambassador was there, and I think Keith's boss was there, and we'd met at that point. So that was sort of our first meeting. And so we've known each other for, I guess, 24 years. I think once we'd met at that, we developed a sort of a business relationship, and with all of these things, we also started to develop a social relationship as well. And I think really over the next sort of 4 or 5 years, I think we became very good friends. We played a lot of golf together. We went on golf trips together. We worked on opportunities between Keith's firm and PwC, and attended some conferences together. So yeah, I think sort of we really got to be, I think, pretty good friends through that period of time, as well as looking at sort of business opportunities together with our respective firms. And I think probably if I can just go on to say, maybe I'd like to sort of take this opportunity if it would be okay. I think, other than a sort of a gap from 2008 when I transferred back to the UK, where we had a brief spell, well, a period until probably 2013, where we'd sort of somewhat lost touch. Keith went to take up a position in Australia. I was back in the UK, and we'd lost touch then. I was really pleased that we reconnected in 2013, and I think the relationship that we then developed over the next, let's say, 10 or 11 years became, I think, very close. And I think anyone who knows me and who I speak to would tell you that I would have said Keith was my best friend. I mean, I trusted him more than I would have trusted anybody else. I think we had a very supportive relationship. I think we had a very adaptive relationship. I think we were sort of adapting to many things as they were coming along, and I think it was very much a sort of as I feel, a sort of a really close friendship, and we helped each other, supported each other, and adapted to many different situations over that 11-year period.
You first moved into the Colwood Court property in 2013, correct?
That's right.
Tell the court the circumstances under which you and Mrs. Gunbie came to live there.
Yes, I mean, I had moved back to PwC in the UK in 2008, which in hindsight probably wasn't the best move because it was just after the financial crisis. So in 2010, I took a package from PwC, and then I decided that I would look at an opportunity with another English gentleman to start a business together, which we did. That went well for 2 or 3 years, but by 2013, it wasn't going well. And having put a lot of my money into it, he put a lot of his money into it, we ended up in a pretty difficult financial situation. The business was really sort of split between London and the US. So I was sort of moving backwards and forwards during that time from London to Atlanta. But obviously my family was in Atlanta, stayed in Atlanta. And so when I came back in 2013, things were pretty difficult. Yeah.
Okay, so yeah, go ahead.
No, you go ahead. Sorry. No, please.
I was going to say, okay, so we were in 2013 and you're having some, financial difficulties due to the, troubles with that business. So tell the court how does, how we get from there to you moving into the Coalwood property.
Yeah, so we had a small townhouse in Roswell, and at that time our sons were probably 2013. They would have been sort of mid to late teens. I got the years right. No, actually they'd have been sort of in late teens, 20-ish. So we were staying there because that was the property that we owned. I had as mentioned, had some of these financial difficulties. We were living in the house, our house, and I don't remember exactly how the connection was made. I think it may have been through a mutual friend of ours, but we became aware that Keith and Liliana were selling their house. Somehow that connection was made, and Keith and Liliana, understanding our situation, offered the use of their property for us to stay and get back on our feet. And I think the one thing I would like to say from what I heard yesterday was, I didn't pick up the phone or call Keith and say, hey, I hear you've got a property that's vacant. Would you, could we come and live there, please? I think it was, that's not the way that it worked. I didn't even actually know that Keith was selling his property at that time. So I think it was a sort of a connection through, as I say, a friend of ours, that it sort of came together.
At the time that you moved into the property, did you enter into a lease agreement?
No, we did not.
Well, what discussions, if any, were there regarding, payment for living at the house?
I mean, there were discussions. So just to characterize the situation, and we will forever be grateful to Keith and Liliana for what they did for us. Absolutely. As you heard yesterday, that Keith advanced money to us to help us. He allowed us to stay in their property at that time so we could get back on our feet. We discussed some business opportunity relating to a valet business that my sons had. But in terms of, I would say at that point, it was, as Keith may have said yesterday, we were friends. And so he very generously said, look, stay in the property until you get back on your feet. We talked about a sort of a rental amount and how we might cover some utilities. But obviously, we were at that point pretty down, and it took some time for us to sort of get back on our feet. And we achieved that because of the help that Keith and Liliana gave us.
What about, so just to kind of circle back, what specifics were there about the amount of rent or other expenses that you were going to provide, as best you recall?
I mean, certainly we discussed the $1,400 a month. That was absolutely, definitely discussed. I think at that time the utilities were still all in Keith's name, and I think we would have discussed that we would try to make payments against those utilities. I think they were in his name and he was paying them. Excuse me. But there was no sort of formal arrangement going on. I mean,
sure. And just because of the lag in Zoom, if I start to ask another question and you start to talk again, I'm going to stop because I want to make sure you get a chance to say. Cut me off if you need to. Tell me, just describe the condition, the physical condition of the property at the time that you and Mrs. Badham took up residence there.
Mrs. Gunbie, I think you mean, but
I'm sorry. Excuse me.
Yeah, I mean, the property was, I would say it was pretty run down. I mean, there were quite a few things that were wrong with the property. There were issues with some of the electrics. There were issues with the HVAC. I heard Mr. Keith say yesterday that, I think his brother-in-law was an architect, which I didn't know, but I know I discussed with Keith over the years that I think his brother-in-law, he said, was a bit of a Mr. Fix-It, and there were quite a few things that were sort of defective, if you like, which included the area down at the bottom of the yard where Keith, I think, had spent quite a lot of money putting in a watering system, which had gone into disrepair. So the sort of back end of the yard was in a bit of a state. The roof was not in good shape. The basement was half finished, with wires dangling all over the place. The HVAC had big silver tubes with holes in them, so that wasn't really working properly. The AC on the second floor didn't work, so we had to go and buy some window units to make that work. So I think my impression at the time was that it had lacked some maintenance, it had lacked some investment, and there were some things that were certainly not up to code in terms of, let's say, the electricity.
At the time you moved in, what instructions, if any, did the Badhams give you regarding, how you should treat the property, what you could do with the property, et cetera?
Yeah, I mean, I think at that time what Keith had said to me was, sort of treat it as home, if you like. Don't feel there's any pressure, treat it as home. If you need to do a few things in the house to make it more comfortable, please, go ahead and do that. But I think his main message was, very supportive in terms of, let us help you get back on your feet. And I think he was accommodating in terms of whatever that meant in terms of the property.
Was there an understanding as to how long you would occupy it? Because did he say they would be coming back in X number of years or anything like that?
No, I mean, we didn't have a fixed timeline. I think from our perspective, we were grateful to stay there and to be able to get that, get back on our feet. Keith was at that time living, I think, in Spain. I think he was in Spain at that point. He said to me many times that he liked living in Spain. He liked the European life. And I think he felt America wasn't the place that he wanted to be, or to bring his sort of family up. And so his intention was to stay in Europe. So that was what I understood his sort of personal objectives were.
Tell the court about, how the discussions came about regarding your the possibility that you might purchase the property.
Yeah, I mean, I think there are, if I may take sort of this opportunity, Knox, I mean, I think there are sort of 4 very clear sort of milestones or timelines that occurred in this sort of whole period of time. I mean, there was obviously the time that we moved in. There was then a meeting that Keith and I had in Valencia in December 2016. So I think, that December 2016 was a very sort of important moment, and we could get on and talk about that in due course. I think the next sort of important milestone was when we signed the purchase and sale agreement in May of 2018, and then of course the final sort of milestone, which was the sort of April 2024. So to come to your sort of question, the the decision really, when we got to December 2016, I think Keith and I agreed that we needed to talk about, what the future was going to look like. We've been in the house for a while. So I went to Valencia to meet with him, and we talked, excuse me, we talked about at that time the potential of buying the house. I mean, we had a very wide-ranging conversation. I think it's worth saying at that point, and I'll sort of just dip into the financial side of this for a moment. At that point, I still owed Keith approximately $79,000 relating to the rent payments, the $1,400 rent payments, as well as the utilities that had run up over the period from sort of 2013 to December 2016. And there was also an amount of approximately $40,000 that I still owed him from some of the loans that he'd given us. So I went to Spain in 2016, knowing that I still owed Keith around about $119,000. But I went with the intention to talk about, we talked about the future. Keith obviously was thinking about the property. At that point, I didn't need to make a decision to buy the property. I mean, we could have looked at other properties, but we were in the property. We liked the property. Keith wasn't sure, I think, at that time what he wanted to do, but it felt, given our friendship, it felt like a good idea for us to look at buying the property. So we discussed that. At the same time, we discussed some career opportunities for Keith. He said to me that he hadn't been in serious work for 2 or 3 years, and he would be keen to get back into some sort of employment or some work. So we talked about the Middle East and what I was doing in the Middle East. I suggested to him at that time that there might be opportunities to get him involved in some projects and contracts in the Middle East, which I think sort of suited him. I think having had the career, and for me, that was Keith was a very experienced CEO, and I could see there being quite a bit of opportunity for that. So I think again it sort of it was very much here were two friends who were talking about some mutually beneficial arrangements that might suit both of us going forward. I don't think either of us had to go down that course, but that's what we chose to do. So in 2016, that's when we really committed to the course that sort of brought us to where we are now, if you like.
So, do you have any idea what the value of the property was in that time when these discussions were ongoing?
Yeah, we'd had an appraisal done, and the appraisal came in at around $395,000. I think it was more or less around that time. So yes, we knew what the property was worth.
Okay.
When was that?
When was that, Mr. Gunbie?
I think it was around that time. It was late 2016, whether it was November or December. I recall it was at that time.
I'm going to share my screen so that we can share documents.
Yeah.
You able to see this document that I've put up on the screen?
Yes, I am.
Okay, this is Exhibit D1, which was admitted yesterday. This is, would you agree that this is the purchase and sale agreement that you and Mr. Badham executed.
Yes, I would agree.
And I will say, this is somewhat of a unnatural way of having this kind of conversation, but if at any point you need me to zoom in or to scroll down, or you need more time to look at something, will you just let me know?
I will, but I can read it fine.
So what was the principal, the sale price that you and Mr. Badham agreed on?
The sale price we agreed on was $450,000.
Okay, and you testified that a moment ago that sometime within, a year or 2 years prior to that, you had commissioned an appraisal and it was $395,000. How did you then arrive at a purchase price of $450,000?
We arrived at that because we felt it was reasonable to apply an uplift to what the market valuation was. And as I mentioned earlier, we had 79,000 approximately of costs and these rents that at that time in 2016, in December 2. Again, I need to point out the $450,000 was a number that we discussed in the December 2016 period. And we said, well, let's put the purchase price of the property at 450,000. We know the market value was 395, but also at that time, as I just mentioned, we also knew that we still owed Keith and Liliana in that region of $79,000. So, we rolled that into the 450,000.
And just
Mr. Withers, I'm sorry to interrupt. I think I misheard Mr. Gunbie a moment ago. I thought I heard
Yes.
it 319,000, but then your question said 390,000. So I want to make sure I heard that correctly.
I don't want to, Mr. Gunbie, for the court's clarification, can you please say again what the appraisal that you got said, what the value was?
395.
Thank you, sir. Thank you, Mr. Withers.
Thank you. And this document that we're looking at, who drafted the initial version of this document?
The initial version was drafted by Keith.
And does this agreement, as far as you are concerned, contain all of the agreements that all of the terms that you and Mr. Badham agreed on, or were there other terms that aren't reflected here?
No, this agreement contains the terms relating to the purchase of the property.
And you obviously heard Mr. Badham testify yesterday that at the time you entered into this agreement, you actually owed significantly more than $450,000, but that you didn't want any of that put in this agreement because you didn't want Mrs. Gunbie to know about your debts. Is that an accurate statement?
No, I don't believe that that's an accurate statement. I mean, Mrs. Gunbie, Kim, knew that we owed the Badhams money.
Is there anything in this agreement relating to personal loans that the Badhams made to you other than, well, I'll just leave it at that. Is there anything in this agreement relating to personal loans that the Badhams owed you?
No.
You mentioned that, I believe, well, how much did it, as far as the personal loans go, at this time, how much did you still owe Mr. Badham?
In 2018?
Yes, sir.
So in 2018, when we got to this point, we would have owed Mr. Badham the $79,000 that I just referred to. And then we had, at that time also, we agreed that we would make a what I would call a flex payment, which was something we agreed when we met in Valencia in 2018. Sorry, I beg your pardon, 2016. So we owed for that, and we also owed for the utilities relating to the for the period up to May 2018.
Okay, so I think earlier you went through $79,000 for rent and utilities. I think you said $40,000 in personal loans. So, and I believe you said that, so at a certain point in time, it was about $119,000 that you owed Mr. Badham. Is that at a different?
So let me just clarify. So aside from the purchase and sale agreement, there were the prior loans of approximately $40,000. There was the flex adjustment of $50,000 that I agreed because I was wanting to recognize the fact that prior to that time we had benefited from the arrangement that the Badhams had supported us with. We also, as of that time in May 2018, owed roughly $35,000 relating to the utilities and, let's say, the rent. So that the $1,400 in the utilities was around $34,000 because that ran from that sort of, if you like, the December 2016 timeframe. Because again, bear in mind the $79,000 that had been incurred prior to December 2016 had been adjusted through the $450,000 purchase and sale agreement. So the total at that time, if I exclude the purchase and sale agreement, the total would have been approximately if I'm doing my math right, $124,000.
Right. I'm sorry, go ahead.
No, I mean, if when I'm going through the numbers, if counsel or anyone would like me to, or the judge would like me to repeat them, I can do that in case anyone wants to write them down.
Thank you. Section 1 says it is proposed that the following buyer payment schedule will be as follows. And then it's got, as we talked about yesterday, 37 payments of $8,000 per month commencing on June 30th, 2021. And then we have the $205,522 to be paid by June 30th, 2021. So if we add all that up, where does that get us as far as a sum?
Well, for the purposes of this agreement, so yes, the total amount was the 450 plus the interest calculation. So I believe it was 501,522, something in that range. I'm not sure I've got the exact number, but it was in that range.
So that includes principal and interest.
Oh, that's right. Yes.
Section 2 is entitled Conditions. Mm-hmm. And Section 2.2 says buyer will cover cost of all repair repairs necessary during the life of the agreement, including maintenance. All utilities will be transferred to the buyer's account. Do you see that?
Yes, I do.
What did you understand wear and tear repairs and maintenance to include? What was your understanding?
Well, for me, my understanding is, when you refer to repairs and maintenance, I would take that to mean making sure that the property is in livable condition, if things break, we repair them. If we need to maintain certain things, then we do that. So I would attribute that to sort of the wear and tear, if you like, on a property.
As far as the utilities go, so it says that you were to transfer them into your own name. Were you able to transfer any of the utilities into your name?
I believe we transferred the gas into our name. I think we did talk about transferring the water into our name. I'm not sure why that didn't happen going back. But I do recall Keith saying, and I actually think he may have said it to my wife, but when we talked about the transfer, that he felt it would help his credit to maintain some of the utility bills in his name. And I'm not sure if sort of if that's a British thing, because I know, when you live in the UK, if you like often get asked for utility bills to sort of demonstrate proof of residence, as well as some credits and other things. So I don't remember exactly why, but I do remember that specifically we talked about there was the utility account that he'd want to stay in his name.
Section 2.3 of the agreement says if buyer wishes to cancel this agreement at any time and for whatever reason, no payments will be returned, nor value given for any repairs or improvements which will belong to the property. Now, you heard Mr. Badham testify yesterday that, when talking about improvements, that was referring to painting the walls and, planting shrubbery and flowers in the yard. What did you understand improvements to mean?
Well, so let me say that I know we'll go through this a bit later. We spent around $276,000 covering maintenance and repairs and improvements to the property. Just to break that down, we spend $128,000 on what I consider to be repairs and maintenance. So, for example, when a retaining wall falls down, I consider that to be a repair and maintenance. If equipment doesn't work in the pool house, I consider that to be repair and maintenance. If I look at some of the work that was done in terms of, let's say, the upstairs bathroom, where we put in the new bathroom, that's an improvement. So I think for me, if things are broken, whether it's the AC, the electricity, walls falling down, trees falling over, that for me is repairs and maintenance.
Section 2.7 says, during the term of the agreement, the buyer will have the right to occupy the property as a private residence, and no rental payments will accrue or be payable. What did you understand this language to essentially mean?
Well, what it means to me is that we're not in a lease, so we're not in a rental agreement. Now,
under the purchase and sale agreement, you were to make payments of 37 payments of $8,000 each. Did you make all of those payments?
No, I did not.
And did you make the balloon payment of $205,522 on or before June 30th, 2021?
No, I did not.
And tell the court why you didn't.
The So the reason I didn't at the time was there were other cash flow impacts that were occurring, particularly in the early 2019 to sort of mid 2000 and late 2020 period. At that time, Keith and I were working daily together in Riyadh. We started a project there in early 2019. We were day to day with each other. There was work that had to be done on the house, and we talked about that at the time. His builder was involved with that as well. And then we hit COVID in early 2000 and early 2020, and at that time, a lot of people were losing their jobs, including family members and so on. So I think Keith and I were fortunate enough that we were both working, but there were some impacts to the cash flow at that time.
But did you make any payments towards the purchase price of the property?
Sorry, in which period, Knox?
Well, let's say during the period between May 5th of 2018 and June 30th of 2021.
Yes.
And did you make any payments toward the purchase price of the property after June 30th of 2021?
Yes.
Okay. As of today, how much do you contend that you have paid toward the purchase price of the principal, or towards the purchase price of the house?
$437,000.
I'm sorry, 400 and how many thousand?
$437,000.
Thank you. Okay. I'm gonna go back. And show you, there we go, what has been marked as Exhibit D2. This was admitted, I don't know if the word is provisionally or conditionally, or portions of this were admitted yesterday. Do you recall the testimony regarding this yesterday?
I'm sorry, you blipped there, Knox. Can you say that again?
This is the Exhibit D2, which was introduced to some extent yesterday, is your discovery.
Okay.
You recall the testimony yesterday regarding these discovery responses?
Yes.
Okay. I'm going to go down to the portion of these discovery responses that we spoke about yesterday. This is your response to interrogatory number 8, which asks about the payments that you made. And this spans pages 4 and 5 of your discovery responses. If you, again, because this goes on to both pages, if you need me to move back and forth between the pages, just let me know and I'll be glad to do that. So these payments that are listed here in response to interrogatory number 8, did you in fact make all of those payments to the Badhams, or to Mr. Badham?
Yes, I did.
And it reflects here at the end, and I represented to the court yesterday that I double checked it, and the total, well, what is the total as you calculated here?
The total on here is 452,166.
Okay, so if the total that's listed here is $452,166, why is it that you say you've only paid approximately $437,000 towards the purchase of the property?
Because it was pointed out to me in deposition that, in fact, I had included some payments in this list that related to the business, which I'm sure we'll talk about in time. So if you look at the the line item starting, I guess, February and March 2023, you'll see there's a total column there of 6,000. It's gone. Where is it? 6,992.
Oh, yes.
Yep. And that's a net number that includes the payments just off to the left and down. You'll see there's, if you go to the 222.23 Knox, you'll see there's a payment of 9,500 euros.
Yes.
And on 3/2/24, there's a payment of $10,000. And there's a payment on February 13th of 936, and another payment on February 4th of 2000. Now those numbers don't add up to the 6,992 because at this point in time I was just picking up the payment information. So when, as I say, it was pointed out to me in deposition that these numbers actually related to the business. So so I should not have included the 6,992, which, as I say, was a net number. And there were two earlier payments pointed out to me also. I can just see them on my screen. I think there was one of 1,241, which I can just see, and I think there's one above that as well, if I'm right. The 2,775. So I had included those, and that was a mistake on my part, and partly caused because I was paying Keith through the Wise banking transfer system, both for the business payments as well as for the personal payments.
Now, did you make any payments towards the purchase price of the property from May of 2019 to January of 2021?
May of 2019
Right.
to I believe that was the gap that I was referring to earlier.
Okay.
And so, yes, the answer to your question is no.
To the best of your knowledge, other than the 3 or 4 or 5, I don't know how many there were, but payments that you erroneously included in response to interrogatory number 8, other than those, to the best of your knowledge, are there any other payments on this list that you believe were for items other than towards the purchase price of the property?
No. And just to clarify, so in the Wise system, I would normally in the payment reference, I would, if it was a business related payment, I would write Connaught payment or something in the Wise document.
Do you know, and I think Mr. Badham testified about this yesterday, but do you know how much you paid toward the purchase price of the property before June 30th of 2021?
Or June 30th.
Before
2020. Oh, yes, sorry. Yeah. I believe that was 114,000.
Now, did Mr. Badham ever send you any kind of default notice when you failed to pay amounts that you were scheduled to pay under the agreement?
No.
Aside from shortly before this lawsuit began, did he ever tell you that he wanted you to move out of the house due to missed payments?
No.
Around June 30th, 2021, when you didn't make the $205,522 balloon payment, did he ever send you notice at that time that he considered the purchase and sale agreement to have been terminated?
No.
Did you continue to make payments toward the purchase price of the property after June 30th of 2021?
Yes.
And other than the ones that, again, you identified that you erroneously included on in your discovery responses, was it what was it your intention that all those payments were going toward?
For me, they were going towards the purchase and sale agreement because that was the only, that was the only formal agreement we had, and that was the agreement we wanted to get executed as quickly as possible. So for me, when I was making these payments, that's where I believed what they were being applied to, what they would relate to.
And the erroneously included payments that you just mentioned, I haven't added those up, but if we take that out of the 452,166, is that how we get to approximately $437,000?
Yeah, that's correct.
If you didn't make the balloon payment on June 30th of 2021, I mean, tell the court why then did you continue to make payments toward the purchase price of the property?
I continue to make the payments because I believe that both Keith and myself understood that the agreement was still, if you like, in force, and he had not given me any notice of termination. And when I made the fairly large payments, which I believe are, again, not on my screen, but if you look at the large payments that were made in early 2022, there were payments there that you can see September. Sorry, let me sit back a bit. So if you see late 2021 and early 2022, there were some very, very large payments that were made. So, at that point, I completely, I 100% believed that the purchase and sale agreement was still in force, and I'd not received any notice from Keith otherwise. I mean, I would also say in the period between when the payments weren't being made, between February, January 2019 and in 2020, as I said to you earlier, Keith and I were together, many, many, many days out of that period. And, not once did he that I recall, write to me and say this was a problem, or that the agreement was terminated. So my understanding was that I was making these payments in good faith on the understanding that the contract was still effectively in force.
You heard Mr. Badham testify yesterday that he believes that you have only paid $114,000 of this $437,000. Only $114,000 was towards the purchase price of the property. Do you recall? Mr.
Yes.
Testify that?
Yep.
Do you agree with that?
I don't, because it's mathematically impossible.
Well,
and let me, sorry, I beg your pardon.
I said just explain to the court why that's not possible.
Because the only thing that the payments could apply to would be the utilities, the other costs, the other loans. If you add up all of those costs and utilities and everything else from the period of December 2016, and remember that the period prior to 2016 was rolled into the purchase price, if you add up the 35,000 that was the utilities and rent from 2016 until we signed the purchase agreement in May 2018. If you then take the utilities from May 2018 through to April 2024, you would arrive at approximately $37,000 of utilities, We then have the outstanding loans of 40,000, and then we have the flex adjustment of 50,000. If you add those numbers up, you come to approximately $161,000. So from an arithmetic perspective, if I've got $437,000 of payments, even if all of those went to those other costs or other items, you can't possibly arrive at 114,000. So just to do the arithmetic for you, if I take 437 and I deduct 161, I would end up, I wish I could do the arithmetic actually, but I would end up around 270,000, I think. So, you know, and many of those numbers are derived from the records that Keith kept. He would have those records. So I frankly don't understand how you can come to the answer of 114,000 was the only thing that was paid towards the purchase and sale agreement. It's not, as I said, the numbers don't add up.
Okay, and just, I was trying to write this down as you were speaking. So can you just—
Do you want me to give it to you again?
I just want to know, I wrote down 35,000, 37,000, 40,000, and 50,000. First,
So let me repeat it for the court. As I said, I think it's important that people get these numbers. So the utilities from May 2008, sorry, the utilities from December 2016 to May 2018. Remember, I told you there are 4 very important milestones here. So from December 2016 to May 2018, there was approximately $35,000 of utilities and rent. Okay, because we hadn't entered into the purchase and sale agreement at that point. Then we then have the utilities that ran from May 2018, after we executed the purchase and sale agreement, through to April 2024, which is when the final payment was made. And that total was approximately, and these are, I'm going to say approximately, $37,000. Okay. We then have the outstanding loans of approximately $40,000. And then we have the flex adjustment that I agreed to of $50,000. And if you add those up, they should be around $161,000. So what I'm saying is that I made $437,000 of payments, and this is the total of the costs. So I'm not aware of any other things that I should be paying for out of that $437,000. So for me, $114,000 is not a number that can be arrived at.
Okay, and just so we're clear, are you, you've just gone through a mathematical exercise based on the testimony that Mr. Badham gave.
Yeah.
But, as far as you said, if you take 162,000 out of the 437,000, that leaves you with whatever that number is. But do you agree or disagree that the $437,000 that you paid actually was intended to include that $161,000 or $162,000 that you just did the math on?
No, I mean, for me, as I just said to you, the priority was to execute against the purchase and sale agreement. And again, if you look at the size of the numbers and when we're talking about 40,000, I mean, if you just look at the numbers, those are not the size of payments that are going towards utilities. So the characteristic of the payments is that they are intended for the purchase and sale agreement.
You testified earlier about how you came to meet and become friends with Mr. Badham, but at that time, early on, were you actually in business with Mr. Badham? Or was it just you knew him through business circles?
No, we knew each other through business circles. Primarily, as I said, we met through the British American Business Group. I was the president of that organization in, I think, 2003. I'm trying to remember if Keith joined the board. I think he did join the board. And, he was incredibly supportive. He got involved with the organization. We ran events together. We did golf days. So, we built a pretty good relationship through that organization. And we then looked at doing some business together between Cognisa, which is his company, and PwC. In fact, I remember we went on a very good trip to Miami and watched Mikhail Gorbachev talk at a business conference. So, we developed a pretty good business relationship, but we didn't actually work together in the same company.
Okay. So how did you go from being professional acquaintances to actually doing business or working with him?
Well, as I said earlier, that came about really in December 2016. So, Keith had retired from G4S, I think around 2013, around that time, and was enjoying a sabbatical. And, by the time in 2016, I'd started with Ernst & Young in January of 2015 in the Middle East. And, we, as friends, we were talking about what he was going to do in the future. And he said, well, I need to earn some income, and I'd like to look at some opportunities. And, you have to keep in mind that, being a contractor on a contract in the Middle East, it carries with it a degree of flexibility. You're a consultant, you're not an employee of a company. So there's a degree of flexibility with that. And as I said, it was an opportunity to take his experience, his great experience as a CEO and his skills, and to put them to use and learn some new things as well. So that was really how we got into it. I think it was I appreciated having him on my team in Saudi doing the projects we were doing, and I think he found it rewarding as also both financially and career wise.
You heard Mr. Badham testify about the consulting contracts that you helped him obtain. Did you?
Yeah.
Did you in fact help him obtain those contracts?
Yeah, I did. I mean, I did more than that, really. I mean, the contracts he worked on were my contracts. I mean, I was the partner responsible for those contracts. One was with the Saudi Rail Company, which started in March, around early March, so March 2017. So this came quite quickly after we'd met in Valencia in 2016. And he came out to Riyadh to work on that contract. He was working on a project that, from a technical perspective, he didn't have a lot of background. So, I spent quite a bit of time with him, helping him adapt his skills and experience from what he'd done in his prior life into being able to do that sort of project. And so that went on for about a year. And then in early 2019, I had another similar project, again, another one of my clients. And so I contacted Keith and said, hey, would you like to join the team? And of course, at that point, he'd acquired the skills, the technical skills from the earlier project. So again, it was a good fit. It allowed him to make some, I think, some good money. I think he probably earned over, as we said yesterday, over $250,000 from it. We were working together. We were enjoying each other's company. I mean, it was a great experience, I think. So I think it was mutually beneficial. And I wouldn't characterize this as, I gave him somebody's phone number and said, hey, call these guys. They've got a job for you. I mean, I invested some time in this, and as I said, I think it was mutually beneficial.
What is or what was Connaught Services?
So Connaught Services was a So the projects that we were doing in EY were, and I won't try not to get overly technical with the court, but were related to fixed assets. So it was to do with physical assets. So that, for example, Saudi Railways, we were looking at, trains and railway tracks and bridges and all that sort of thing. And you would, it was about sort of compiling and valuing lists of assets. So having done those projects, we felt there was an opportunity to do that in a different way as part of Connaught Services. We thought that some of the contractors that were doing that type of work locally were pretty poor quality. And so I think we felt like we could, between us, and with 2 or 3 other people in the region, we could put a good team together and make that happen. So that's really what the company was about.
So were you and Mr. Badham joint founders of the company, or joint owners, or however, whatever kind of company?
No, I owned the company.
So you hired Mr. Badham, right?
Yes.
And because of his skill set, I guess, and the work that you've done.
Yeah, I mean, we as I said, we worked on the projects in EY together that were very similar. It was in the same space, in the same country, dealing with the same clients. I enjoy working with him, and I trust him and trusted him then. And I think we both felt it was a great opportunity. So it seemed as in terms of building the team and having the right people, it was talking to Keith about it seemed a good, the right idea.
Is Connaught still in operation today?
No, it's not.
Why is that?
Really because I think we misjudged the market. I think we believed that the Saudi clients would be interested in a quality product, a different way of doing things, and I think we probably misjudged that. So we didn't get the contracts that we hoped we would get.
So yesterday, Mr. Downs introduced a copy of Mr. Badham's employment agreement with Connaught. Was that employment agreement with Connaught Services, or was he did you personally employ him?
No, that was the Bahraini contract with Connaught Services.
Okay. You've identified, I'm going to go back to sharing here. You identified some payments in this document that were, as we said, inadvertently credited towards the house, but were actually business purposes. And Mr. Downs asked Mr. Badham about the fact that those payments were made from your Wise account.
That's correct.
The answer to the question, was it to his Wise account, or was it to some other? I know Wise was involved with somebody.
Right. So we both have Wise accounts. I mean, it's actually an excellent service. It's particularly if you're working international. So we both had Wise accounts. The company did not have a Wise account. The company had a local bank account. Keith, I mean, one of the reasons for him having the Bahraini contract was so that he could obtain Bahrain residency, and from there he would be able to open a Bahrain bank account, which I don't think he did. So when it came time to make the payments, he said, let's do it, do it through Wise, and it didn't really make any difference to me. And I think his preference at that time was to receive currencies in different places, because he was moving between France and Spain, and he had different tax statuses in those countries. So as I say, Bahrain is, for me, is it's a tax for there's no tax in Bahrain. But I think Keith had those considerations in his mind. So I said, look, it doesn't matter to me if I can pay you through Wise or I can pay you any other way. So that's how we did it, and that's why there's a mix of, if you look, that's why some of the payments are in dollars, some are in euros. I think there's a couple in pounds as well.
Mr. Badham testified that he did not receive all of the compensation that he was due from Connaught. Do you recall him testifying to that effect?
Yes, I do.
Was his statement there accurate?
I mean, based on the Bahrain contract, then his statement would be accurate.
Right.
But what I would say is that, you know, the last, as he he's set out in I think more than one document that was submitted as part of discovery. He received his last salary in, I believe, January, February to 2023. At that time, we hadn't got the contracts that we hoped we would get, and we continued working together full time. I mean, if anyone would care to go through the discovery documents, you will see there are tens of thousands of WhatsApp messages between us. So we were still working very hard together. From that sort of that time frame, from February through till sort of April 2024. So I think at any point there, Mr. Badham or Keith could have looked for other opportunities, but I think we both felt it was worth the investment of our time, given some of the things that we were working on.
Mr. Withers.
Yes.
It would be helpful to me, and what I'm not hearing clearly is you've referenced this spreadsheet a number of times, and clearly there are a number of, as Mr. Gunbie characterized, large payments made to Mr. Badham during a time period allegedly after the purchase and sale agreement had ended, allegedly, but also during a time that they were doing business as Connaught. And so what I'm not hearing an answer to, and would be helpful to me, is it Mr. Gunbie's position that these large payments that were made beginning in September of 2021 through to at least March of 2022, that those payments were all to be credited? His intention and his understanding was that they were for the house, as opposed to payments for work done and payable to Mr. Badham because of Connaught. That's what I'm not understanding.
Thank you, and thank you for the question.
Could I clarify that for you, Your Honor?
Sure.
Mr. Badham did not start with Connaught until June 2022. So the payments that are occurring before that time are not related to Connaught.
Okay, thank you.
And then just kind of the last question that I have regarding Connaught is, understanding that the business ultimately did not succeed, and I'm sure you would understandably feel bad that the business did not succeed, but did you at any point were you under the impression that you were personally guaranteeing Connaught's payments to Mr. Badham?
No.
Now, we've talked about the loans, and you said, I believe, and please correct me if I'm wrong, but that as of roughly December of 2016, you had some about what I wrote down was $40,000 balance on the loans. Did I write that down correctly?
The loans that dated back to 2013, 2014. Yes.
Go ahead. Finish your answer.
Yeah. No. I'm just saying. I believe $40,000 is the correct number from that time that it was paid down to. So yes. Sorry.
That's no problem. How much did he loan you in total?
I believe the number was it was over 100,000. I think it was around 106. I think was mentioned yesterday. It was in that order.
And do you recall how many loans there were that made up that $106,000?
I do not recall the actual number of individual transactions that made up that amount. No, I don't. I think I heard yesterday was I don't remember the number, Knox. I'm sorry.
That's no problem. Were any of those loans, memorialized in writing?
No. You mean by an agreement?
Right, like a loan agreement or a promissory note or anything like that?
No, they were not.
Were there any documents dictating the terms, the payment terms?
No.
And you said, I mean, obviously, if you got down to $40,000 by December of 2016, obviously you had repaid some of those loans?
Correct.
As of today, do you contend that there is, as of today, any outstanding balance on those loans, with the understanding that you contend that $437,000 in payments was towards the purchase price of the house? If the court were to accept that as accurate, do you contend you still owe Mr. Badham any money today on the personal loans?
Yes, I would still owe him that money.
And is that still the $40,000, or is it some different amount?
Well, I would consider it to be the $40,000.
Has Mr. Badham ever called that balance due?
No.
Can you, what I'd like to do, Your Honor, is, and I just don't have all of Mr. Downs's documents in digital form. I have them in paper form. So would it be all right with the court? Okay. I'm going to stop my share. If you could pull up your exhibit P2.
Sure. You don't mean you're going to adjust the middle one, are you? Okay. Don't touch the podium.
Oh, I'm sorry.
I just want to make sure you're loud and clear. God. Just have the audio feedback. Okay.
Thank you.
Thanks, Will. Okay, on your screen, you have what Mr. Downs marked yesterday as Plaintiff's Exhibit 2, which is a December 30th, 2020 email. Recall seeing this yesterday?
Yes.
It says, "Hi, Matthew."
I'm sorry to ask it. Oh, thank you. I was just about to ask that.
Oh, okay.
I got it. No, you.
Okay, it says, "Hi, Matthew. As requested, the up-to-date position, including utility payments outstanding of $10,841.74. Is that amount, to your knowledge, is that $10,841.74 as of December 20th accurate?
Yes, to my knowledge, it would be. I'm just thinking because the clock was started on those utilities around, well, in December 2016. So at this point, we are at the end of 2020. So that could be the right number.
Okay, and you said the clock started on those utilities in December of 2016.
Yes.
So you had been accruing utility obligations since you moved in, and you didn't sign the purchase and sale agreement until May 5th of 2018. So explain to the court what you mean by the clock started to run on those utilities in December 2016.
Right. So as we said, there were certain utilities that were being paid by Keith, namely the water, the electricity, the pest control. I'm not sure that's a utility, but the pest control and the payments on the HVAC. So although the HVAC didn't come until later, but those utilities were being paid by Keith from the time that we moved into the property. As I explained earlier, there was a cutoff point in December 2016. So all of the utilities and rent at that point, the past, between 2013 and 2016, December 2016, were sort of rolled into the purchase price. So those utilities and costs don't sort of reappear later. So when I say the clock started in December 2016, because that was the date, that was the time that we said that $450,000 would be the purchase price. And as I explained earlier, that was how we got to that.
The next line says there have been no payments for 20 months and the agreement, technically void at the moment, is due to end in June 2021. You see that?
Yeah.
So if the agreement was void as of December 30th, 2020, as Mr. Badham testified yesterday, how could the agreement be due to end in June of 2021?
I don't know.
Well, based on your discussions and dealings with Mr. Badham, did you understand that the purchase and sale agreement had actually been terminated as of December 2020?
No. If I'd understood that, I would not have made the payments that came later.
Right. Okay. And why is it that you didn't understand that the purchase and sale agreement had been terminated as of December 2020?
Because although this document says it's technically void, there was no written notice that the contract was cancelled, and then subsequent to that, there was some, there was quite a lot of payments and some large payments that were made. So my interpretation of this was that the agreement was still in force.
Okay. It says this date also included the additional flex, though this is a handshake off the agreement. Mr. Badham testified yesterday that the flex was a plug or a number the parties agreed to get them where they wanted to be. This is just a foreign concept to me, I think. Can you just explain to the court a little bit more or give a little clarity as to what flex means?
Yeah, so I think the concept behind that was that, as I said at the outset, Keith and Liliana were very generous with us. They were very generous over the first few years that we were in the property. Keith was very understanding. So when we got to the point of agreeing, what we would be paying for, part of the flex related to the fact that we had been paying $1,400 a month, and perhaps it was fair that we paid more than that. And part of the flex was, I would describe it as a goodwill payment. I mean, it was me agreeing that despite sort of everything, that it would be fair for us to sort of make a discretionary payment. That you can call it a flex, you can call it discretionary, but but that was the nature of that. And so the initial flex was around $60,000 at that time in December 2016.
He next says, let me have the revised payment plan to include the flex, and then we can discuss. If, as Mr. Badham testified, he understood the purchase and sale agreement to have been terminated, why, if you know, why was he asking you for a revised payment plan?
Hello.
Sorry.
Don't worry, somebody's phone just randomly made noise. It's fine. Go ahead.
Sorry. Sorry, Knox, can you repeat the question?
Yeah, I mean, if as Mr. Badham testified yesterday, the agreement was void as of December 30th, 2020. If you have any understanding, why is he then asking you for a revised payment plan?
Well, because I assume that he would have, like I did from this, that the agreement was still in force, and so you know that the payment plan at that time in 2020, sorry, the end of 2020, that we were still moving forward with it.
He says, I will let you know when Oscar needs to come around with his engineering guy after the new year. Who is Oscar?
Oscar was a building contractor based in Atlanta. He did a lot of work for Keith and Liliana before we moved in the property. I think they have friends, or there's a personal relationship with Oscar as well. So when we moved into the property, Keith said, you know, if there's any work needs doing, you know, get Oscar in. He knows the house. He's, you know, worked here for us. He's very good. So I can't remember specifically what this particular issue was in December 2020 with an engineer. But, you know, Oscar, as we'll talk about probably later when we talk about the improvements and the repairs, you know, Oscar did a lot of that work. So he was the sort of the go-to guy when sort of things went wrong.
And do you know Oscar's last name?
I think it's Pizarro. You know, I'm not Pizarro. I don't know. You're probably better asking people alongside you. I don't remember his. I think it's Pizarro, but I might be wrong. I'm sorry.
That's okay.
I don't think it's material to the outcome of this case.
No, I don't.
Okay, well, can we go to the next series of pages, please?
What exhibit was that? Two? That's what I thought.
Plaintiff's Exhibit 2. So
Thank you.
if we go to the spreadsheet that Mr. Badham attached to this email, and let's just, thank you, well, start at the total, on the first page, it says start total 450 plus rent plus int, which I assume is interest, plus flex, and then it has an amount of $742,000. And I assume, but I didn't create the spreadsheet, that this is just based on the columns there, that this is around June or July of 2018. But regardless of June or July of 2018, you know, do you agree that you owed Mr. Badham $42,000 at that time?
No, I don't. But I would need to clarify the answer to that, Knox.
Well, go ahead.
So, as I explained to you earlier, when we got to the point in May 2018, that May 2018. Let me get that right. Sorry, wait a minute. I'm just having a. So the 742,000 is there in July 2018. So when we got to the point where we were doing the actual purchase and sale agreement, which is the next sort of milestone that I referred to earlier, we, at that point, as I said to you earlier, in December 2016, we had arrived at a total outstanding amount of 626,000, and I'll break that down for you. Which, sorry, I beg your pardon. That's including I need to back out the 501. So the prior loans at the end of 2016 were $40,000. There was the flex adjustment of 50, and then we had the rent and utilities for that period of around 35,000, which I think I explained to you earlier. So once we hit May 2018, we then added the 501,000 in the purchase and sale agreement, which adds up to the 626. We then agreed that there was some additional discretionary payment. So I beg your pardon. By the time we got to 2018, there was some additional utilities, that were. I'm just trying to think what the number was. Let me get this right. In May. So we had got to a number of 600. When I rolled forward to May 2018, we'd got to a total of $661,000, which included the 501,000 of the purchase and sale agreement, and then it included about $161,000 of utilities, prior loans, flex payments. So we got to a total of 662,000. So added to that was the original flex payment of 60,000, and which is the piece that I referred to as a discretionary payment. And we then bumped that to 742,000 with another discretionary flex payment to get to the 742.
Okay, so, I'm sorry, Mr. Gunbie. Let me, because the math you just did adds up to $742,000, but the original question you were asked by Mr. Withers was, do you agree that in July of 2018, you and Mr. Badham had agreed that you owed $742,000? And your original answer was no, but then the math you did adds up to the 742, and so I'm confused.
Yes, Sharon, let me explain that. So what I'm trying to explain is that they're included in the $742,000 is approximately 60. I'm just trying to get from the 600 and the actual. It includes discretionary payments, which were not loans.
Mr. Gunbie, forgive me, I'm going to interrupt you. So. Yes. I took notes when you were outlining what you believed was owed at sort of the beginning of when you started negotiating the purchase and sale. And you said there was $35,000 in back rent, $37,000 in back utilities, $40,000 in maybe loans, and $50,000 in flex. I'm not exactly sure what those two numbers were, but I knew that they were in there, and that got you to the 161. And then the 501 purchase price gets you to the 662 that you just mentioned a moment ago. And then I think I understood, and that's where I interrupted to make sure I was clear. I thought I understood you to say that gets you to the 662, and then at some point we agreed to an additional flex of some amount of tens of thousands of dollars that got you to the 742. And so I understand that your position is that, I think I understand that the 742 was for more than the house, quite obviously. But the question I'm trying to get to is, do you agree or disagree, yes or no, that for whatever reason you had agreed as of July 8, 2018 to pay to Mr. Badham some combination of payments for loans, for rent, and payments for loans for the house, utilities, etc., totaling $742,000.
So let me try and address that, Your Honor. So the $742,000 that is in in Keith's spreadsheet includes two discretionary payments that were agreed one agreed previously and another one of $62,000. So what I'm saying to you, those payments don't represent loans.
I'm sorry,
there's no basis for those other than the fact that I was saying to Keith that, again, because I wanted to, I was appreciative of what had passed before, that I would be prepared to make some additional, as I say, discretionary payments. But there's no, that money isn't owed to him in terms of a previous loan or any kind of previous agreement or a cost or a utility bill that he incurred.
Yeah, it's a delay. I mean, I have this happen frequently. Sorry for interrupting, Mr. Gunbie. I understand that it probably matters to the individual parties a great deal how these funds came to be owed or why they were owed. And I'm not intending to characterize that there was some formal agreement or that there was a past debt that was owed. Whether it was a flex payment, whether it was a goodwill payment, what I'm trying to get to is the number that Mr. Badham starts his spreadsheet with is 742, and the math you're doing seems to add up to that number, but you are still saying that you did not have an agreement with Mr. Badham to pay him that amount for whatever reason, goodwill, repayment of past loans, utilities, past rent, payments towards the house. I'm just trying to figure out if that number 742 was at least in July of 2018 an agreed upon number that the parties, that however you got to that number, that was the number that was agreed you would be paying in some form or other to Mr. Badham.
No, I'm sorry. Your Honor. What I'm saying to you is that there was no agreement to pay that additional amount. There is, I mean, it's a number in a spreadsheet. But it's not an agreement. It doesn't represent a loan. It doesn't represent anything more than me saying that I would make that. I would propose making those discretionary payments.
Okay. Wait. I'm sorry. Let me ask you this: the number you got to was 662,000. Would you agree that as of July 2018 that you understood that you were supposed to make payments to Mr. Badham or that you owed him, et cetera, for up to 662,000?
At May 2018, the total was, I believe was 626,000.
Okay, so that's a no, and I'll let you take over from there, Mr. Withers.
First of all, I am confused, and then there's a lot of numbers, and as the judge said yesterday, the law school, because they told us there would be no math. Mm-hmm. At one point, you've said 626, and at another point, yes, 662.
Right. Sorry. So, as I said to you, there are various dates here. So at May 2018, the total had reached, in terms of what I felt I owed, excuse me, I owed Keith was the 501,000 for the sale and purchase agreement. There was the prior loans of 40,000. There was the flex adjustment of 50,000, and then there were around $35,000 of the rent and utilities between December 2016 and May of 2018, which is how I got to the 626,000.
So respectfully, when I do that math, it adds up to 662, not 626. But it does seem like at least we get to some agreement at that number, right? The numbers you listed during your testimony, Mr. Gunbie, were 35,000, 37,000, 40,000, 50,000. That's $161,000. And then add just price plus income. 1,000, 161 plus 501, is 662, I think.
Let me just, apologies, Your Honor. I just want to say that, so the 501 plus the 40 plus the 50 is 90 is 591.
Mhm.
Plus the 35,000 makes, takes it up to 626.
Plus 37,000 for back utilities. I thought you gave both a 35 and a 37.
No, I'm sorry. There are between the excuse me, between the period of December 2016 and May 2018, there is a chunk of utilities, which is the 35,000, and that includes some rent. There is the previous flex agreement of 50, there were the prior loans of 40, and there was the sale agreement of 501. So that in May 2016 got to 626,000.
Okay, and then as of July of 2018, is that where the additional 37 comes in?
No, well, there's a small gap between May 2018 and July 2018. I mean, it was because I used the spreadsheet starts in July, the one that's being shown, and the purchase and sale agreement commenced on the excuse me, on May of 2018.
Okay.
Okay.
There's a 2 month gap, and I can't account for why that would be.
Okay.
But I was, let me just see if I can, and I apologize, but there are a lot of numbers. But the 626,000 at May 2018, which I've just broken down, was complemented by the original $60,000 flex that we agreed back in December 2016, or discretionary payment, whatever we want to call it, and an additional 66,000 to get us to the 742.
So I wrote down during your earlier testimony that the $37,000 for utilities, that you said that accrued between May of 2018 and April of 2024.
That's right.
Okay.
That's right. There was another, so that again, clocks, it's not the clock, but once we excuse me, got to the May 18 period, there's then obviously more utilities, because the difference being this: when we get to May 2018, that 36,000 is including, let's say, rent, if we want to call it that, and utilities. Once we get past May 2018, we're just dealing with utilities. Does that make sense?
I'm not sure, but
I think I'm tracking, and I think the reason I got is because that 37,000, I had it accruing as of 18.
right.
I'm going to ask one last question that I think we do get to, again, because of the reference to I was told there'd be no math. So I'm going to go back, Mr. Gunbie, to my original question, but hopefully with the right dollar amount. The original question that started this entire back and forth was, you were asked whether or not you agreed that as of July of 2018, that you had some agreement in place to pay to Mr. Badham $742,000. And you said no. And what I was looking at was trying to find where you did agree how much you owed, and if there was an amount agreed. And is it correct, Mr. Gunbie, that as of July of 2018, that you would have agreed that you owed Mr. Badham $626,000?
That's correct, Your Honor.
Okay.
In terms of loans and past dues and things like that, yes.
Okay.
And I
Thank
think maybe this will fully close the loop on that. My question to you was not whether, as of the date of this spreadsheet, you had agreed that you would pay Mr. Badham $742,000. That was not my question. My question was, as of the date of this spreadsheet, do you agree that you were indebted, that you owed Mr. Badham $742,000? That's my question.
Right. And so my answer to that is no.
Thank you.
Because it's not a debt.
Okay. Now, Will, can you go to the last page of this spreadsheet? Mr. Gunbie, bearing in mind that the top line of, because you can't see it here, but on our paper copy, the top line is start total 450 plus rent plus interest plus flex. As of June, excuse me, I'm sorry, Will. No, I think you're good. I think you're good. Okay, if we look at not the final column here, but the second to final column, which is December 2020. You see that?
Yes.
At that point, Mr. Badham contends that you owe him $670,338.40. Do you see that?
Yes.
And does that amount include whatever the remaining balance on the purchase price of the house? Does it include that amount?
Yes.
Okay. So my question for you is, if, as Mr. Badham claims, the purchase and sale agreement had terminated by that point due to a lack of payments, and therefore if it had terminated and he's of the position no longer have the right to purchase the house, how is it that you could still owe money toward the purchase price of the house?
Well, I couldn't if the excuse me, I got a frog. No, I couldn't. I mean, if the agreement was terminated or cancelled, I would not owe that money.
Okay, and to be clear, the $450,000 for the purchase price that was owner financed, did Mr. Badham ever give you that money and then you turn around and pay it back to him over time? Were you ever in possession of that $450,000 or the 501 once you count interest? Were you ever in possession of that money?
No.
Okay, Will, if you could pull up Exhibit P3, please. Okay, Mr. Gunbie, do you see plaintiff's Exhibit 3 on your screen there?
Yes.
All right. This is another email. This is dated January 11th of 2022. This is a spreadsheet that Mr. Downs introduced yesterday during Mr. Badham's testimony. Do you recall seeing this at that time?
Yes.
Okay, the third paragraph says, I suggest, well, was Mr. Badham working for Connaught at this time?
No.
The third paragraph says, I suggest you transfer $200K in USD to my Wise account, which I will use to pay off the mortgage. Do you see that?
Yes.
Okay. And do you recall yesterday, Mr. Downs asked Mr. Badham whether you had actually paid that $200,000?
Yes.
Mr. Badham said that you had not. You did not, correct?
That's correct.
Okay. Will, I'm going to go back to exhibit. Yes, please. Thank you. Okay. I am going to show you Mr. Gunbie. I want to go back to your interrogatory responses. That email that we just looked at was January 11th, 2022.
Mm-hmm.
According to your records here, how much did you pay Mr. Badham in January of 2022?
$22,400.
How much did you pay Mr. Badham in February of 2022?
I just want to object just for the record that I think those initial payments that he's referring to are before the date of that email. To the extent you're trying to credit them for the email, that's okay.
All right, well then I would forget January of 2022. February of 2022, after you had received this email from Mr. Badham, how much did you pay in February of 2022?
$40,000.
How much did you pay Mr. Badham the next month in March of 2022?
$45,000. Oh, and two, actually there were two payments, one for 45 and one for 40.
Okay, Will, if we could go back to exhibit P3, please. I'm gonna stop sharing.
Okay.
Or is it, yeah, P3. Okay, so these payments that you made in, well, in January of 2022, in February of 2022, and in March of 2022, those payments, you know, those add up to $147,400.
Mm-hmm. Yes.
Yeah, I'm just going to object that those,
I understand.
portion of those payments are after, predate this email.
Right. I'm going to talk about the December 2020 email. So the January 2022 payment of $22,400, the February payment of February 2022 payment of $40,000, and the March payment of March 2022 payment of $85,000. All of those were after Mr. Badham had told you in exhibit P2 in December of 2020 that the agreement was technically void, right?
Yes.
Okay, and if we look at this exhibit P3, he says, once I have the lien released from Truist, we can close out the rest and make that the sales price. What do you think? Now, at the time that you received this, did you understand that Mr. Badham thought you no longer had the opportunity to purchase the property?
No. I would say the opposite.
Your Honor, I don't know if anybody needs a break, but I'm ready to switch to a different subject matter. So I'm happy to go forward, or if anybody needs a break.
Okay, well, in candor, I'd hoped that we'd be done by now, but we obviously are not, so might as well take a break. It is 11:11. We're going to call it 11:15, and we'll take a 10-minute break and try and get back in here. It's probably going to be longer, truthfully, court time, closer to 11:30, but let's try to get back in here as close as we can and be started by then.
Thank you, Your Honor.
Thank you.
Do you have a 25, 30 minutes? Okay.
All right, sorry about that.
No, you're fine. Thank you so much.
Is it going all right with the video? Like, okay.
Yeah, I just hate that, because it's like, within Fulton County, there's specific courtrooms, and they'll just have like the audio feedback, and I can't do anything to prevent it, like I tried to turn this off.
It's like a static noise or something.
It's like a weird alien noise.
Okay.
It's like, yeah, literally that's the best way to describe it, but you can hear everybody still talking, it's just, I feel bad for the transcribers, because that's all they're hearing when they're listening to the meeting. But if they really get annoyed, they could just utilize the backups, you know, that's what they usually do. So.
Yeah, it's too
And
much.
we've tried, like, there's been many instances, it's just if I catch the courtroom, I'm like, I just notify transcription, so they're extra cautious and they just know to use the backups. And
Yeah.
as long as they're running, they don't die. And that's why I kind of moved them closer to you guys, because I wanted your voice to be loud and clear. It's a big call. Yeah, but he's picking up fine.
Okay.
Yeah, it's a pretty good setup for Zoom.
That's good, yeah.
Yeah, because I was like, ugh, I'm worried.
So it's on silent, but they, you know how they leave a voice message and it transcribes, I wanted to read it. And I think I must have hit the button to talk, and so it was. Because I have to, before no one second, I have to do my benefits. Maybe if we get home, then I'll do that.
No worries, please be seated.
I'm just consulting my, it's weird, because some people need like login, so she'll take me your minute.
Okay.
Okay, thank you, and I'm ready to go back on.
Excellent. Thank you. So we are back on the record after a brief break. And Mr. Gunbie, I'll just remind you that you were sworn in when you began testifying, and that even though we took a break, you are still under oath. Mr. Withers, you can continue your examination.
Thank you. So, Mr. Gunbie, I want to switch now to talk about the improvements to the property that we've been talking about. That we talked about yesterday. And I'm gonna again share my screen, and show you, we looked at this yesterday. This is your response to interrogatory number 15, which asked you to provide information about various improvements that you made to the property. And again, this covers 2 or 3 pages of your discovery responses. So if you need me to move to a different page, just let me know. But generally, my question is, did you in fact, you and your wife, make all of the improvements that you listed in your discovery responses?
Yes.
And do the amounts listed here accurately reflect what you paid for those improvements?
The vast majority accurately reflect that to the dollar, in the sense that we had receipts and bills and records. Just given the process of time, there were a few smaller amounts that we did not have records for, but we knew from various communications what the amounts were.
Okay. And what was the total value, or the total approximate value of those improvements?
The approximate value was, well, can we just be clear? Because the improvements, let's say the total amount we paid was 276,000 approximately.
Right, that was my.
Yeah, well, I just want to distinguish, Knox, between improvements and repairs and maintenance.
Oh, okay.
So the total amount that we paid was 276,000. Out of that amount, 128,000 approximately related to what I would call repairs and maintenance.
Okay, thank you. Did you ask the Badhams permission to make all of these improvements, or at least tell them you're going to make them?
Not in that sense. There were some expenditures that were required that we did specifically talk about with Keith. Some of the others, as I said, during a lot of time, a lot of this was happening. We were together in Riyadh, and we would talk about what our wives were doing, and you know, what was sort of generally happening in our personal lives. And you know, I know we talked about, you know, some of the things that we were doing at Colwood. So and also I know that obviously for a lot of these projects we were using Oscar, the famous Oscar, and you know, we know he was in communication with Liliana, so we know that she would have been aware of some of these. So explicitly, did we ask permission? Not for all of them. But again, by this point, when all of these were happening, we were within the purchase and sale agreements and after, and you know, our understanding was that what we've been told in terms of treating the property as our own was what we were applying.
Yesterday, Mr. Badham testified that other than the retaining wall and the new roof and the HVAC system, he didn't have knowledge of any of these improvements. Do you recall him testifying that?
Yes.
And do you believe that that's an accurate statement?
For the improvements or the repairs and renovations, or both?
All of it.
I think there were some others that he might have been aware of, like the fallen trees, and I'm sure there were some others that we talked about. But specifically, I can't tell you. I mean, I do know that the wall we talked about, because we had a WhatsApp group that relating to the wall, and we had messages backwards and forwards about whether the insurance would cover it or whether it wouldn't cover it, and likewise with the roof. So explicitly, some of those, obviously, we were in discussion with him.
You've rented residences before, correct?
Yes.
Do you believe that you're generally familiar with property expenses that a tenant is expected to pay for and that a landlord is expected to pay for?
Yes.
I'm not gonna go through all of these, but I do want to highlight a few. Between, for example, number 3, between November of 2022 and June of 2023, you said that you paid $93.10 to fix broken pipes in the basement.
Yes.
Your experience as a residential tenant, have you ever been expected to repair pipes?
No.
In number 4, you said you spent between November of 22 and June of 23, you paid $3,000 in electrical repairs. In your experience as a renter, have you ever been expected to pay electrical repairs to get the building up to code?
No.
In 2020, in number 21, you said that in January of 2022, you paid $11,000 and change to repair the collapsed retaining wall. Have you ever been expected to incur an expense as a renter for structural repair like that?
No.
In number 22,
Your Honor, I'm going to object to this continuing line of question. I think we can get the point.
Okay. That's fine. Let's,
I agree. Keep going.
all right.
Move on though, please. I mean, I don't think from what I've heard, although the testimony I've heard, right, and correct me if anything I say is wrong, is that Mr. Badham, although he asserts that he wasn't consulted about some of these projects, or that perhaps the interrogatory lists them as perhaps being more costly than they were, he's not disputing that improvements were made by the Gunbies to the property. The question is whether or not they were for the benefit of the Gunbies under the purchase and sale agreement, or if it was expected that after termination, those improvements would inure to the benefit of the Badhams. So.
Understood, Your Honor. I'll skip over all of what I was going to ask and just ask Mr. Gunbie simply this. The vast majority of these repairs, which are not in dispute, is it fair to say that the majority of them you made after Mr. Badham had told you that he believed, or that after he says the agreement was terminated?
Are you referring to the January 20, the December 20 email where he said it was technically void?
Yes.
Then that would be correct.
I'm going to show you now Exhibit D10. And I'm going to short circuit this a little bit, but I do think, we talk so much about what was going on, but I do think it may be informative just to have an idea of what we're talking about. So I'm asking you if you recognize exhibit or the photographs in Exhibit D10.
Okay.
What do these photographs show?
This particular photograph shows the front view of the house, and when this photograph was taken, I believe it still has the old front door in place.
But generally, these show what the pictures we're going to look at show the house.
Correct.
And do they truly and accurately reflect the condition of the house at the time the photographs were taken?
Yes.
When were they taken, Mr. Withers? Mr. Withers? And I'm only asking, were they taken recently? Were they taken in April of 24? Were they taken in May of 2018?
They were taken, and as we look through, they were taken at different points.
I see. Thank you.
So let me ask you just please, Mr. Gunbie, just as quickly as you can, tell me what these photographs generally show.
Okay, so this is a photograph of the old front door and of the new front door. And the old front door needed replacing because it was starting to rot.
What does this second paragraph show? Photograph, series of photographs.
This shows the hallway inside the front door, where the picture on the left is with the old tiling, which, as you can see, is very cracked, and on the right is where we put some new tiling down.
Okay. This next picture, what is this? What do these show?
This is the master bathroom. On the left is the bathroom as it was when we moved into the property, and on the right, obviously, is the way it looks today.
Okay. What about the next page, these pictures?
Yeah, this is the pantry off the kitchen, and on the left is the way the pantry was again when we moved in, and on the right you can see that we've installed some cabinets and put some new tiles down.
Okay, what about this next picture I'm showing?
Yeah, the picture on the left is the old deck, which was becoming dangerous because it was rotting, and on the right is where is the new deck, where we basically had to rebuild the deck.
What does this next picture show? For
this is showing, sorry.
This series of pictures.
So, well, these are pictures of the basement where the drains started leaking, were breaking, and the only way to deal with it was to dig them up.
Okay, these next series of photographs, tell the court what these show.
This is the retaining wall, and you can see there that it's collapsed on the left, and on the right you can see the new retaining wall.
Okay, and then these?
The picture on the left is the gazebo, the old gazebo, which again was rotting and actually was dangerous. The beams were falling off it, and so we rebuilt it, and that's the picture on the right.
Okay, and then these photographs, what do these show?
So these two photographs show on the left where they are starting to build the fire pit, and on the right is the fire pit once it was completed. And this is the back area that I referred to earlier, where, as I said, Keith had invested in I think there was a gathering lawn there and there were some pipes, but when we moved in, it was just a mud patch.
Okay, and then finally, these photographs, what do these show?
The photograph on the left is the view of the backyard from, I guess, one of the windows up on the house, and on the right is a view of you can just catch the new gazebo there on the side of that photograph. So that's after we did that.
Thank you. Your Honor, I spoke to Mr. Downs during the break. Was going to ask some questions about payments to the registry, but I think, and I'll let him confirm, that we can stipulate that the Gunbies have made the payments into the registry of the court in the total amount of $92,393.64. And that if you do the math based on the state court's order, I believe it was $21.72 for the mortgage and $408 for the utilities. And that if you add up all of those payments, that $92,393.64 could be broken down into roughly $77,000 in mortgage / rent, and between $14,000 and $15,000 in utilities. And I'll let, that'll save me having to ask some questions, but I'll let Mr. Downs say whether he'll agree to stipulate to that.
Yeah, I mean, they made all the payments that the court has ordered them to make to stay in possession of the property. I did not do the math as to the breakdown, but I'll stipulate that they've paid all of them.
Okay.
Thank you.
Before we switch topics entirely, it sounds like y'all do have a stipulation. But before we switch topics entirely, you had spent some time going over the improvements that were listed, showing pictures of them. What I don't know that I have in my notes is what is the total dollar amount that the Gunbies allege they spent and or enhanced value or whatever their argument is about the improvements and maintenance, et cetera, that are listed in 20 and that were shown to me in interrogatory response 20 and shown to me in photographs.
Sure. And I, because it's not my testimony, I'll let Mr. Gunbie answer the court's question.
Mhm.
But so Mr. Gunbie, if you heard, first of all, let me ask this, are those photographs, do those show every single improvement or renovation that you did?
No, it's a selection or a sample.
Can you answer the court's question, at least as to, of the 276,000 total that you spent, how would you break that down between repairs and maintenance on the one hand and improvements, renovations, capital improvements, whatever, on the other hand? Am I getting your Judge?
Yes.
Okay.
Yes. So the repairs and renovations, the repairs and maintenance, which includes things like the roof and the wall and the plumbing. The repairs and maintenance came to approximately $128,000, and the balance, the total amount was approximately 276,000. So the improvements, we would be at 276 less 128.
Right. And I come up with 138.
Thank you, sir.
And I did want to ask just one question about not about the registry payments themselves, but specifically, if we go back to your interrogatory response to number 8, by its own terms, the state court's order says that it covers the period from November of 2022 through October of 2024. That was the initial $61,000 payment that you and your wife had to pay. Did you, during that period, before you were ordered to pay into the registry of the court, to cover that period, did you also make payments directly to the Badhams during that period?
Yes.
Yesterday, Miss Del Rio Badham suggested that, while she was living in Bordeaux and sending her child to a private school, you and Miss Gunbie were also living the high life and taking European vacations and, talk about getting a lake house. Did you in fact buy a lake house?
No.
Yesterday, you and, Mr. and Mrs. Badham testified that they were essentially dumbfounded that you would refuse to move out of the property when they asked you to, given all that they had done for you. I think it would be appropriate for you to explain to the court why you could not agree to their request that you move out.
Yes. Well, I mean, first of all, I would like to draw the court's attention to the testimony from Miss Badham, who in her testimony, I think, implied that we were essentially freeloading off them for the last 11 years. And I think what I hope in my testimony I can have demonstrated is that was not the case. I mean, there was no intention for us to freeload, and I don't believe that we were. So I think that's an entirely inappropriate characterization of all that we've been through. In terms of them being dumbfounded by, let's say, my reaction, I think you have to take into account how this proposition was put to me. I understood that the Badhams wanted to move back to Atlanta because their son wanted to attend Riverwood High School. I had discussions with Keith about that prior to when he visited the property in April of 2024. I know they were looking at some other options. It's still in Barcelona, and we had a number of discussions about what some alternative solutions might be. And bear in mind, at this time, we were still working very closely together on projects. So I think Keith and I might pride ourselves in saying that we're people that like to find solutions to problems. And so we were talking about, how could we find a solution to this problem? And, one of those solutions that we suggested was, since they intended to only be in the US, for 3 years, that maybe the option might be for them to rent a property in Atlanta, and since they wanted to go back to Spain, that would be work in everybody's interests. I think I think what perhaps triggered the emotion side of this is that the way it was put to me was that we needed to vacate the house by July. This was we were told this in April. We were told that, this would just be a period of 3 years and we could go off and enjoy a life in Barcelona. And there was no discussion or proposition from Keith or Liliana on, what does that mean in terms of either everything that had gone before in terms of all of the financial financial transactions and everything else. There was no let's sit down and go through this and look at what you've paid for, what we've paid for, where are we. It was simply you need to move out of the property. So my reaction to that was to write back to Keith and say, I hope that we would be able to find a solution to that. But that it was, in my view, it was an unreasonable request to come to me in April and tell me I have until July to leave the house for a period of 3 years, with no discussion on how that could possibly occur, whether it was from a financial perspective or whether it was from the practical perspective. So I felt I'd written back in I think quite a polite way and listed my reasons as to why I thought that wasn't doable or practical, or why we wouldn't want to do that. And the response I got from Keith in writing was he felt that I had impugned his integrity, and obviously you've heard the testimony yesterday from Liliana that she was somehow dumbfounded by my response, that I felt that their suggestion was, in the circumstances, entirely unreasonable in the way that it had been presented.
Thank you. So just to confirm, and I promise, Your Honor, I am almost done here, but just so we can put a little bow on this. You contend you paid how much towards the purchase price of the property?
$437,000.
Not including the portion of your registry payments that have gone to cover the mortgage, right?
That's correct.
And of the $276,000 that you've paid for, repairs, maintenance, and improvements, your testimony is that you believe 128 is the amount that were for repairs and maintenance, and the balance was for, improvements?
Yes, that's correct. And I'd like to add to that, Knox, that, I would under no circumstances have made any of those payments had I believed that the purchase and sale agreement had been in any way terminated or cancelled.
And when you refer to payments, you would not have made those payments. Are you talking about?
No, I'm sorry. Sorry, I'm lagging. No, I would not have made those expenditures.
Okay. For the improvements.
Correct.
Do you have any, notion of what the value of the property is today?
I believe it's in approximately around $850,000, something in that range. We've not had it appraised, but I think it's somewhere between 800 and 850,000 if you consult Zillow. I generally don't look at Zillow, but that's what I understand.
I'm going to object to his opinion of that if he hasn't laid the foundation for opining as to that.
Okay. Well, I generally might agree with you, except that I think he said he thinks that's what Zillow says, and we've allowed other testimony regarding Zillow. And so I'm going to allow it.
Consult Zillow? I mean,
That's what I understood him to say.
I don't think that's what he said.
Mr. Gunbie?
May I just clarify that, Your Honor?
Sure.
I said I don't consult Zillow, but my wife, looks at properties, and she does consult Zillow, and that's what she told me.
I object on hearsay grounds.
Okay.
That's fine. I'm sure.
Sustained.
I'm sure the court can look up on Zillow if Your Honor is so inclined. Let me ask you this, Mr. Gunbie. Do you believe, because you can testify without being an expert, that the value of your property, of the property, has increased as a result of the improvements that you and your wife have made?
Absolutely. Yes.
And as Mr. Downs did yesterday, I'm going to say, is there anything else that you'd like to tell the court about this matter that I have not asked you?
Well, thank you, Knox, for giving me the opportunity, and I think I would just like to thank the court and the judge for hearing my testimony. I think the one thing I would just like to ask, Your Honor, is can I clarify anything further on some of the numbers? I know that was quite an exercise to go through that. So if you would like any further clarification, I'd be happy to do that.
I appreciate that, Mr. Gunbie. What I would likely do is I'm going to let Mr. Downs conduct his examination, and then when he's done, if I have any additional questions, I'll ask them, and then give both the lawyers one more opportunity to follow up with you. But thank you for inviting me to do so. As I said, I have made some notes, and to the extent that I don't feel like I've gotten those questions answered, I will definitely follow up. But thank you.
Other than that, Mr. Gunbie, anything else?
No, I think that's nothing else. Thank you, Knox.
Nothing further, Your Honor.
Thank you, sir. Mr. Downs, questions for this witness?
Sure.
All right. Good evening to you, Mr. Gunbie in Saudi Arabia.
Good evening, Mr. Downs.
I wanted to clarify one thing at the outset about the circumstances, your agreement when you first came to the property in 2013. I understood your testimony to be that you did have an understanding for the $1,400 in rent, but you also had an agreement that you would maintain the property, correct?
At that time, yes, we had an agreement that at that time we would, if there was obviously anything that needed fixing, that we would fix it.
All right. We looked at the 2018 purchase agreement earlier with your attorney. Do you recall that?
Yes.
And the agreement says that if the buyer, which is you, fails to make any payment for 6 months, then the buyer is assumed to have canceled the agreement, right?
Yes.
And you testified that you did not make any payments throughout 2020, correct?
Yes.
That's more than 6 months, right?
Yes.
But you also failed to make any payments from April 22 to September 22, correct?
April 22 to yeah, I don't have that in front of me, Mr. Downs, but I will take your
yeah, I'm happy to refresh your recollection on that. So from April 22 to September 22, you have made no payments, right?
Yes.
That's 6 months too, right?
Yes.
So by the agreement's own terms, you, the buyer, canceled it, right?
The agreement was set to expire in June 2021, but I did not explicitly cancel the agreement.
Right. You didn't notify Mr. Badham that you canceled it, right? But by not making payments for 6 months, you did cancel it, right?
By what's written in the agreement, yes.
And Mr. Badham doesn't have to provide you any notice if you don't make payments for 6 months, right?
I'm sorry, can you say that again?
Under the agreement, Mr. Badham doesn't have to give you any notice if you don't make payments for 6 months. It just cancels of itself, right?
Correct.
And you talked a minute ago about how the agreement calls for a termination date of June 30th, 2021, right?
Yes.
And the agreement also says that during the term of the agreement, the buyer will have the right to occupy the property as a private residence, and no rental payments will accrue or be payable, right?
Yes.
But you stayed in the property after the termination date, didn't you?
Yes, by consent of the owner.
And you didn't pay any rental until you were ordered by the court, right?
We didn't pay any rental, Mr. Downs, because we were still making payments against the purchase and sale agreement.
All right, after the original agreement, after the agreement terminated in June of 21, we looked at some email, you and Mr. Badham continued to have discussions about you buying coal, right?
Correct.
We'll put this exhibit we looked at earlier up. This is plaintiff's 3, which we looked at earlier with you. You recall this discussion?
Yes.
And this is after the agreement, after the agreement's termination date, correct?
Yes.
And you see in this email where Mr. Badham is asking you to transfer $200,000. We already talked about that, right?
Yes.
And he's asking you to get your attorney, after you do that, to draw up some documents, right?
Yes.
And you didn't respond to him and say, why do we need to draw up new documents? We already have an agreement, right?
I did not respond to this.
Yeah, you didn't respond to say, why are you asking me to do a new deal, Keith? We already have a deal.
Well, I didn't do that because I'd continued to make the payments after the June 30th date.
And isn't the reason that you made the $125,000 in payments in February of 22 because of this email?
Well, because this email implied to me that the agreement was still in force, and therefore I was making payments against it.
How does this email apply the agreement is still in force where you're not agreeing on the sales price?
No, but what I'm suggesting, Mr. Downs, is that at this time in January 2022, Mr. Badham is asking me to transfer $200,000 into Wise, which must relate to the agreement, the purchase and sale agreement that existed between the May 2018 agreement.
He's asking you to come up with a new sales price for the property, isn't he?
the nature of the, well, I think if I understand, and again, this is going back in time, but what we're suggesting here is the $200,000 was to be applied on the mortgage, which then meant we would look at what would be left to, not a purchase price, but what would be left to pay against the original agreement.
Right, so you haven't come up with a number for the agreement. You're trying to figure out what the new price is going to be after the agreement's terminated, right?
No, that's not correct, Mr. Downs.
That wasn't your understanding?
No.
But you didn't, nonetheless, you didn't even transfer the 200, did you?
I didn't transfer the 200, no.
So you didn't even comply with his other request that you know, for this new agreement, you didn't even comply with that, did you?
I didn't comply with his request for a new agreement. There's not a request for a new agreement here.
I'll show you another document. I don't think your attorney.
And sorry, Mr. Downs, may I just make a clarification?
I think you answered the question.
Well, hold
No,
on.
I'd like to ask a clarification. I think Mr. Badham was allowed to do that yesterday.
I am going to allow him to do it. Go ahead.
I think the point that I would like to make is that while I didn't transfer the 200,000, you at no time have any of the amounts that I paid to Mr. Badham been applied to the mortgage.
Well, I'm unclear as to why you felt the need to clarify that. He's asking you to transfer 200,000 to pay off the mortgage, but you didn't transfer that. So how could he pay off the mortgage with money you didn't transfer to him?
Well, it doesn't. What this document doesn't specify is exactly how much he would use to pay off the mortgage at what time. So when I made the payments in February and March, you know, none of those payments were used to apply to the mortgage.
Well, I guess we can agree to disagree on that because I think it's pretty clear he's asking for 200 to pay off, but we can move on. In October of 23, Mr. Badham sends you this email, right, Mr. Gunbie?
Yes.
And in this email, he's sending you a new sales agreement, right?
He sent me a draft sales agreement. Yes.
A new proposed sales agreement, right?
Yes.
Okay. There's no email or message or WhatsApp from you to him saying, Keith, why are you sending this to me? We already have an agreement, right?
That's correct.
And I haven't seen anything where after the 2018 agreement has expired, I haven't seen anything where you're proposing to Keith, hey, I know this agreement has expired, but here's what we should do going forward. I haven't seen anything to that effect, right?
In terms of an email, no. But again, we were in close proximity on a day-to-day basis, and we would have talked about matters relating to this. But no, there is no written communication.
I mean, there's nothing in writing at all prior to you hiring an attorney that suggests you still thought you had rights to the 2018 agreement, right?
Nothing in writing.
One second, I'll pull something else. We'll pull up defendants exhibit 6 that we looked at, I believe, yesterday with Mr. Badham. scroll
Could
down.
you expand?
This is an email that Mr. Badham wrote to you in September of 22. And in this, he's calculating the amounts that you owe for 15 months of payments, right? It says outstanding 15 months, July 21 through September 22 times 2172 equals 32,580, right?
Yes. Sorry, this is the calculation of the mortgage payments.
That's right. He's sending this to you, right?
Yes.
And he's saying he's sending this to you because apparently you had asked about catching up the Coalwood position.
Yes.
And so you're specifically asking him, what are the carrying costs that you're sustaining since the agreement expired and I didn't buy the house?
Yes, I'm asking him to catch up on the payment state, on the position of the payments.
And then on your response to him, you say you're clarifying this, what these costs are for, right? You're asking, does the 2172 include the mortgage, right?
Yes.
And in essence, you are agreeing that you owe him those additional amounts, right?
Sorry, please, which additional amounts are you, can you, please, could you expand the screen a little bit? It's a little difficult to read.
Oh, zoom in, you mean?
Yes, sorry, yes. Okay, thank you. Sorry, could you repeat the question, Mr. Downs?
Sure. You're agreeing with it, or you're trying to come to an understanding of what amounts that you owe him for his carrying costs since the May 2018 agreement expired, right?
I'm asking him a question about some numbers that I guess would have been contained in a spreadsheet.
Right, and those numbers include the costs that Mr. Badham was incurring for the property since July 21, right?
I think I was confused by the reference to the mortgage payments, because there's no obligation on my part to be paying his mortgage payments.
That's not what you're trying to do in this email, is figure out how much you owe him since July 21?
I think what I'm trying to understand is the costs that were incurred relating to utilities and other costs. And where I think I was confused was the fact that it was the 2172, because that's a mortgage payment.
Okay, so you're trying to figure out just what the utility costs are, right?
I believe so.
And you agreed you owed him those amounts.
The utility costs.
Right.
Yes.
You owed him those amounts for a time period after the agreement terminated, right?
As I explained earlier in my testimony, I owed him for the utilities from May 2018 onwards, actually before that.
And also in this, you're specifically looking at the purchase sheet, the spreadsheet that we've looked at, right? You referenced the spreadsheet from January 20 that we looked at, right?
No, I'm not, because the mortgage payment of 2172 does not appear in that spreadsheet. So I would have been looking at something else.
You can just listen to my question. I'm not asking you about the mortgage payment anymore. What I'm asking is a different question. In this email, you've looked at the purchase sheet from January 22, right?
Can you be clear? The purchase sheet for January 2022 is an exhibit, is it not?
The one you looked at with your counsel. In this email, you're referencing that you looked at that sheet for purposes of this email.
Well, I would ask you why I'm asking the question, what is the 2172? Because that does not appear in that sheet.
So in other words, you got the spreadsheet, you had the ability to look at it, and you had the ability to clarify when you thought terms were incorrect, right?
Could you put the spreadsheet back on the page so that we can see if the 2172 is in there?
So I think that's not my question. That's not my question. I'm not asking you to go into detail about the 2172. If you'll listen to my question, what I'm asking is, based on this email, you're receiving the spreadsheets and you're reviewing them, and you have the ability to clarify when you don't understand certain charges, right?
Yes.
And the only exhibit we've looked at throughout this whole case where you're disputing charges or questioning charges is this one mortgage charge, right?
I'm sorry, Mr. Downs. I'm not following you, because the exhibit with the spreadsheet does not contain a number of the mortgage number of 2172. So in asking my question of what is the 2172, how can I be referring to that spreadsheet? I'm sorry, I don't understand your question.
Let's just move on, because I don't know how I can make it clearer. All right, you referenced this in your testimony, but you wrote an email to Mr. Badham in May of 2014 after he asked you to vacate the property, right?
Yes.
May of 2014.
May of 2024, sorry. I'll share it with you so we can be on the same page. This is
Hang on. I'm sorry to interrupt.
Yeah.
Mr. Badham, I think you might need to go let Ms. Badham back into the courtroom because we don't have a deputy. The door's locked. And so I think she's locked outside. Sorry for the interruption. Go ahead.
And no worries. All right, this is Plains 12, which I don't think we've looked at before.
But it was admitted.
Yes, was admitted. All right, you wrote Mr. Badham an email in May of 2024 after he asked you to vacate, right?
Correct.
And in this email, I'm going to highlight this section for you. But you wrote to him that the payments made from me to you between July of 2018 and January 22 totaling approximately $360,000 against the property, monthly expenses, and prior loans, right?
Yes.
But that's not your testimony today, right?
Sorry, could you just expand? I'm sorry to ask, but I'm having difficulty reading it. Can you just zoom in a little bit for me, please? Yes, I see that.
And that's what you wrote in May 2024, right?
Yes.
So the $360,000 at that time to you encompass not just the payments for the property, but the expense payments and prior loan payments, right?
Yes, but I don't know the accuracy of the $360,000 at that time.
But now that we're here at trial, you're now claiming that you should get credit for $430-something thousand just towards the property alone, right?
Yes.
You want all of the payments that you made to Mr. Badham since July 2018 to go to the property. All of those $430,000 payments, and not to monthly expenses and prior loans as you wrote in May 24.
Well, at that time, none of the payments had been allocated. I mean, they were lump payments. They weren't allocated. So I think I would have been referencing the basket as a whole. So I don't think there was any allocation of those payments.
Right, but in this email, you're allocating them to 3 different things, right?
Well, I haven't allocated them because I haven't assigned an amount against each one of those buckets.
Well,
those categories.
Now that you're assigning to prior loans is 0.
Well, I haven't specified that.
For purposes of trial, you are, right?
Well, yes, I am. That's correct.
And $0 goes to monthly expenses, right?
Correct.
All of the payments should go towards the property. Now that we're at trial and you're trying to keep the house, right?
Sorry, is that a question?
I can move on. But let's do this. We looked at your spreadsheet earlier with your attorney. I believe I looked at it too, of your history of payments. You recall that?
Yes.
Let me pull it back up for us. And I guess just before we move further, I really didn't follow when you were saying how you reduced this down from 452. So can you please walk me through this slowly, which specific line items you're now taking off?
I believe the line items that were coming off were the $6,992 that were in 2023, where it says February, March with an asterisk. And the other amounts were, I believe it was the fourth, and I'm just trying to see, this is the 4,016 and the 3,167. I don't have the reconciliation in front of me, but I believe those are the payments.
I'm really sorry. So you're saying now that you don't know what line items on here you've taken off? Other than the 6,900?
I don't have the details to hand, but from recollection, the payments that I made an error with in terms of when I prepared this and submitted it were the October's payments of 2,775, the 1,241, and the so the totals on those is 4,016 and then the 3,167, and then the 6,992.
Okay, so just to clarify, the $4,016 reference on October 2nd, 2022, you're now taking off of the spreadsheet, right?
I included it incorrectly.
Okay. And you included the $3,167 on November 21st, 2022 incorrectly?
Yes, I believe so.
And you included the $6,992 charge on February 4th, 2023 incorrectly?
Yes.
So if you subtract those, I come up with $437,991. Does that sound right?
I have not got a calculator, but that sounds right.
Well, I mean, it's your case. I mean, you're the one claiming that these items, the specific dollar amount that you're claiming was paid for the property. So is it that number? Is it 437,991?
I believe the number that I quoted was an approximate 437,000.
Why can't you be?
Mr. Downs, let me ask you a question. My recollection of Mr. Badham's testimony yesterday was that, other than maybe some of the issues we're discussing now, that he didn't dispute that these payments had been made, Mr. Badham. He disputed what they were for. And if that's the case, I understand that how he got to his numbers might go to other issues in the case, but I think you've made your point in terms of
specifics. Then.
Yeah.
All right, so included in your calculations of how much you paid are these three line items from December 21st, 2022 and December 29th, 2022, right?
Yes.
Okay, and those total $15,000, correct?
Yes.
Do you recall, did not mean to stop sharing. Do you recall telling Mr. Badham around that time period that you were going to transfer $15,000 to him for house costs?
I don't, what you're telling him verbally or in some other form?
It was a WhatsApp.
If I don't recall that particular WhatsApp.
Okay. Well, fortunately I have it here so we can look at it. All right. You see this?
Yes.
Okay. All right. In December 21st, 2022, you sent Mr. Badham a message saying, also, I should be able to get across $15K to you next week relating to house costs, maybe a bit more.
Yes.
Right? Does that refresh your recollection that you wrote that to Mr. Badham at that particular time?
Yes.
you still contend that that 15,000 was for the purchase of the house?
I would say that that particular message references house costs, so you know that could apply to the house purchase, or you know, any of the costs. It's
Well,
not specific. It doesn't specify.
but you use the plural costs in this message, right? You didn't say house cost or house purchase. You said costs, which we've discussed are the utility payments that you've been making, right?
I'm going to object, Your Honor, that mischaracterizes the witness's testimony.
Well, I agree with you, and I feel like we can move on because we've used the word costs multiple times, and I've heard this witness say costs, and I've heard Mr. Badham say costs, and so I'll decide what I think they all meant by it.
You recall at your deposition, Mr. Gunbie, that we talked about the former employee of yours at Connaught, Miriam Adnan.
Yes,
And Miriam Adnan kept the books for Connaught, right?
that's correct.
And you previously testified that she kept accurate books and records.
Yes,
And she sent you an email detailing Mr. Badham's open balance with Connaught to date in April of 24.
yes, she did.
I thought that one of this February 22nd, 2023 entry for 9,500 euros.
Go ahead.
Is included on that ledger, Mr. Downs. That's correct, which is why I removed it after we went through discovery.
But you haven't removed it, sir.
Actually, I have, Mr. Downs, because the 6992 is a net number. So when I prepared this, I was only picking up the payments. And so the 6992 is a net number because there were some payments back to Mr. Badham the other way. Sorry, going the other way. So the 9,500 euros and the $10,000 and the $956 and the $2,000 were included on the ledger. But when I prepared this, which I was in error the way that I did it, I took a net number of 6,992, which is what I removed from, which I've agreed was incorrectly included.
I really don't understand that because we went through specifically like what you were removing from the calculations. You did not reference this line item.
Well, if you look at the $10,000, if you look at the $10,000, the 9,500 euros, the $956, and the $2,000, it does not add up to 6,992.
All right. What about the journal entry for 5/2/2023 for $2,000? Did you remove that? And this I'm referencing now is Miriam Adnan's ledger.
Yeah, that's the $2,000 above.
So you removed that too.
Yes, I did.
Did you remove the $3,148.53?
Sorry, which number, Mr. Downs?
Right, I think it's on yours. It's three. You did remove the 3,167 too.
That's correct. And I would like to make a point, Mr. Downs, that this ledger was obtained after Mr. Badham left employment and after Mr. Adnan left employment. So from a Connaught perspective, this ledger should not have been distributed the way it was.
Do you recall that in December of 2023, that Connaught had just received an influx of cash?
I don't recall that, Mr. Downs.
Okay. Let's look at. All right, this is a WhatsApp between you guys from December 21st, 2023. And that's your message to Mr. Badham there. Starts with, I'll go through the reconciliation with Miriam, but after all of, I believe that's the staff settlements, there should be a reasonable amount of cash there for you and me. The only trouble is we won't receive it until next week. You recall that?
I'm having trouble reading it, but I will take the fact that you've read it.
Well, I don't want you to take my word for it. I'll zoom in further.
Yes, I see that.
And then do you recall that you did in fact begin distributing money to Mr. Badham after that Connaught cash came in?
I don't recall those transactions, not off the top of my head, Mr. Downs.
All right, well, here's one from December 22. Just sent you 2,000 pounds. Is that pounds and wise?
Mhm.
Euros. Yeah. Then December 27th, I just sent you another 5,000 euros. December 28th, another 5,000 euros. January 11th, $12,000. So you started distributing quite a bit of Connaught distributions to Mr. Badham after this money came in, right?
I don't see that these distributions relate to that Connaught money.
You don't think that they're related?
Well, I'm not saying that in these messages.
You're talking about business.
I'm sorry?
So throughout these messages, you're talking only about business, right?
I don't see a business reference in these messages.
Well, who's Sam?
Sam is my brother.
Is he involved in the business?
No.
Who's Salah and Mahmoud?
Salo was, I believe he was an employee of PwC.
Was this related to Connaught?
Yes.
And you certainly don't reference anything in these WhatsApps about Colwood, do you?
No, I'm not referencing any. I mean, I'm not referencing anything about Colwood in these WhatsApp messages. But I'm not sure. Sorry, I'm not sure your points, Mr. Downs.
Well, my point is simply that what I'm asking is that you now want to characterize these December payments as property purchase payments. Correct?
I'm saying those are property related payments. And if you were to go back through the thousands of WhatsApp messages between Keith and I, you would find there is a mixture of messages where I'm saying I'm transferring money to him, and the next WhatsApp might be, how did the meeting go? There was not a separate WhatsApp account for business.
So it's just a coincidence then that when Connaught receives this influx of cash at a time when Mr. Badham is undertaking efforts to you and he are in business together, that these are all now just related to Colwood? That's just a coincidence?
Your Honor, I'm going to object on the grounds that there's been no evidence or testimony that there was an influx of cash. What I believe the message said is they should be receiving some, but Mr. Gunbie has testified, if I understood him correctly, that didn't materialize.
Regardless, here's what I got from all that, and we can move on. Those WhatsApp messages that Mr. Downs was referencing track pretty closely payments that were being made on the spreadsheet in 23. And Mr. Downs wants to, using the context of those WhatsApp messages, characterize those as being business payments. And I'm sure that what I've heard from Mr. Gunbie is that they are not. And that will be a matter of fact for me to decide.
Thank you.
Would you agree with me, Mr. Gunbie, that any confusion about the allocation of payments is your own fault?
I would say it's a function of the fact that the payments were being made through Wise, which I explained to you earlier.
I'm not just talking about those particular payments we just looked at. I'm just saying in this case as a whole. We looked at a prior email where you said there's $360,000 for the property, prior loans, and expenses. You later revised it to $452,000. You've later revised it to $437,000. My question is simply, isn't the confusion about all of this your own fault?
I would admit some blame in that, Mr. Downs.
You could have made things a lot clearer by adhering to a payment plan or agreeing to a payment plan, right?
Well, I think there was a payment plan. So when you say making it clearer, you're saying distinguishing between different types of payments.
Yeah. I'm just saying you could have made it a lot clearer what you were paying money for, right?
Well, I would say both Keith and I could both have made it a lot clearer because his spreadsheets don't allocate the payments either.
Even if this court were to give you credit for all of the payments that you've made since January 2018, that's not the full purchase price from the house for the 2018 agreement, right?
I'm sorry, could you repeat that? I missed it, Mr. Downs.
Even if this court were to give you credit for all of the payments since 2018 that you're now claiming, that's not the full purchase price of the house per the 2018 agreement, is it?
That's correct.
And there is no agreed upon time frame for you to make the, was it roughly $70,000 in additional payments that you would owe?
That's correct.
There's no installment schedule for the 70,000, is there?
There's no installment schedule at either, or I can say schedule if you prefer. There's no installment schedule for that either Keith or I drew up. But as we know, the state court drew a schedule up for us where we pay, as you know, $2,172 a month into the registry.
Yeah, I'm not talking about that. I'm talking about the balance of the purchase price under the 2018 agreement. There's no agreed upon payment schedule, is there?
Not that Mr. Badham or I made up.
And you have never issued payment in full for the balance, have you?
Well, if I were to take the payment that I believe was made, and I have then paid $77,000 approximately through the registry, then I would say that I have.
Setting that issue aside, that's court-ordered payments for a different purpose. So setting aside that, you haven't issued payment for the remaining balance under the agreement, have you?
I have not made a direct payment to Mr. Badham for the agreement.
And you didn't even make the other payments until you were court-ordered, did you?
Well, the other payments were court ordered on the basis of a dispossessory, I can't say the word, a dispossession claim.
If the Badhams never wanted to move back to the property, could you go, what, another 20, 30 years paying the $70,000 towards the purchase price? Is that fair?
I think that's an impractical suggestion, Mr. Downs.
How long? How long would it be? How long could you string out the $70,000 for?
I don't think I understand that question. When you say,
We can move on.
well, would you like me to say 100 years? I'm not sure I understand your question.
Mr. Gunbie, I understand his point to be an argumentative one, but to be that he's trying to direct the court's attention that there were no clear boundaries or terms for payment, because you can't specifically say how long you had to make the remainder of those payments. That's the point he's making, and I'll take it for what it's worth, and we can move on.
Thank you, Your Honor, and I appreciate your clarification on that.
The agreement that we looked at says that if the buyer, which is you, wishes to cancel the agreement at any time, and for whatever reason, no payments will be returned or value given for any repairs or improvements, which will belong to the property. You recall that?
Yes.
And in section 2.4, we looked at how no payments for 6 months is a cancellation, right?
Could I ask you to put that back on the screen, please, Mr. Downs?
Sure.
Sorry, could you just refresh which we were talking about?
Yeah.
Which one was?
In 2.4, no payments for 6 months is a cancellation, right?
Yes, as we discussed before.
And regarding the property repairs, if I understand your testimony, is that you only recall discussing the roof and the retaining wall with Mr. Badham? Is that right?
Specifically, I remember those because they were part of written communications, but I believe I also did discuss trees at some point, and there may have been others, but I don't recollect.
This time, you don't recollect anything else.
No, I don't.
And you didn't ask Mr. Badham's permission to perform repairs, did you? Other than the roof and the retaining wall?
Well, I think under given the nature of this agreement, it was our responsibility to make those repairs. Which goes to the earlier agreement as to when we first moved in, that we would make necessary repairs and maintenance.
So is that a yes to my question then? You didn't ask Mr. Badham to perform any other repairs?
Not that I recall.
And you didn't expect Mr. Badham to reimburse you for the cost of your repairs, did you?
No, I did not, because I believed we had a purchase and sale agreement that so I would not have expected that, because I didn't believe that we were in a lease where I would have expected him to pay for the repairs.
And you didn't ask Mr. Badham's permission to make any improvements to the house, correct?
Not specifically.
Mr. Downs, can I ask you to clarify your language just a bit? Because you're saying you didn't ask Mr. Badham to make any improvements. I think what you mean is you didn't ask Mr. Badham his permission for you to make improvements. And it could be interpreted as you didn't ask him to make those improvements, like for him to do it. I wanted to make sure I understood what your question was. I think I did, but I wanted to clarify.
Yes. Let me rephrase it then. You didn't ask Mr. Badham's permission for you, Mr. Gunbie, to make improvements, did you?
No.
And you didn't tell Mr. Badham about any of the specific improvements to the property you made, did you?
On the improvements side, I don't recall informing him directly of any improvements.
And you didn't expect Mr. Badham to reimburse you for any of the improvements that you made, did you?
Not under the terms of this agreement.
You testified you received notice from Mr. Badham in April 2024 that he wanted you to vacate the property, correct?
Yes, he asked me in April 2024 that he would like us to vacate the property.
You didn't discuss that with Ms. Gunbie until May 2024, right?
That's correct.
And ultimately, you did not move from the property, right?
That's correct.
When he asked you to vacate the property, you didn't have a lease agreement for Colwood Court, right?
That's correct.
And when he asked you to vacate, you had not completed the purchase of Colwood Court, had you?
Not at that time.
So when he asked you to vacate the property, you didn't have any legal document allowing you to stay, did you?
I object to the form to the extent that calls for a legal conclusion.
Yeah, I'm going to allow it in terms of his understanding of what there was.
So to answer your question, I believed at that time that since we continued to make payments, that the purchase and sale agreement was not terminated. So on that basis, I believe that I had a right to be in the property.
But we talked about earlier how the agreement specifies a termination date, right?
We did, but I think what we're addressing, and I'm not a lawyer here, we're addressing the specific performance relating to this contract.
Well, you're not an owner, right? You're not the owner yet, and you're not under a lease. So how does this document give you the right to stay in the property?
Because I don't believe that the contract was terminated. I had I was never given written notice of this contract being terminated. Payments were continued to be made, and I believe that specific performance would say to me that the contract was still in force.
Well, speaking of specific performance, under this agreement, you don't get the deed until you make all the payments, right?
That would be correct.
And you never made all the payments, so you don't have a deed, right?
Yes.
So if you're not the owner and you're not a tenant, you're just there with their permission, aren't you?
No, I'm there under the terms of this agreement.
That you think is still in place.
I do.
You're a British citizen, correct?
Yes.
You don't have a green card to be in the United States, right?
That's correct.
You're here on an ESTA, which is a visa waiver.
I was.
Right, you were, right? Not anymore.
That's correct.
And an ESTA is good for 2 years.
That's correct.
But under an ESTA, you can't stay in the United States for more than 90 days at a time without having to leave and re-enter, right?
That's correct.
It's really considered a tourist visa, right?
That's correct.
So you're preventing the Badhams from returning to Colwood even though you're not allowed to be at the property for more than 90 consecutive days, right?
I'm just processing your question, if you bear with me, but I'm not sure that my length of time that I can stay at the property has any bearing on my preventing the Badhams from repossessing the property.
And you didn't list Colwood Court as your primary residence for purposes of your ESTA application, did you?
No.
I mean, you couldn't. It's a tourist visa. You can't reside in the United States, right?
That's correct.
For the past 7 years, you've leased an apartment in Spain, right?
That's correct.
You pay approximately $3,000 per month for this apartment.
Yes.
So that's $36,000 annually.
That's correct.
And you've remained current on those rental payments during the time period in which you weren't paying Mr. Badham timely for Colwood, right?
Yes.
Beginning in 2015, you became a partner with Ernst Young, right?
Yes.
You testified you worked for them in the Middle East, right?
That's correct.
And you worked for them from 2016 through 2023, right?
Yes.
You earned over $500,000 a year, right?
Yes.
And you weren't taxed on that salary, were you?
No.
So throughout 2020, when you didn't make any payments for Colwood Court, you were making over $500,000 a year tax-free, correct?
Yes.
And at the same time in 2020, where you're not making any payments, you did manage to pay $18,580 to improve your backyard patio and build a fire pit.
Yes.
And you managed to spend $6,300 to improve your poolside deck.
Yes.
I mean, in total, didn't you make over $80,000 in repairs and improvements during a time period in which you weren't paying the Badhams?
I don't have the total breakdown in front of me. But if I can clarify, as I said earlier, during that time period, we were, working together on a day-to-day basis.
Well, this is my numbers here based on your numbers. So from November 2019 through August 2021, you didn't make any payments to the Badhams. Yet the total paid for repairs and improvements looks like it's $84,000, right?
Yep. Yes.
Your testimony was that cash was just real tight during this time, right?
Yes.
Mr. Badham allowed you to begin living in the house in 2013 without paying any rent, right?
Yes.
He also personally loaned you money, right?
Yes.
And in 2018, you and he agreed on the terms for you to buy coal, right?
Yes.
But you didn't fulfill those terms by the agreed upon deadline, despite making over $500,000 a year, right?
Yes.
Yeah, he continued to live in the house after the agreement expired by its terms, right?
Yes.
And on several occasions, as we've looked at, he presented you with other options to buy the house, right?
Yes.
But you never came to an agreement on any other terms, right?
No.
Wouldn't you agree that it's solely your fault that you're not the current owner of Colwood Court?
I would have to answer that question. Yes.
Yeah. I mean, there's nothing Mr. Badham did to prevent you from owning it, right?
I haven't suggested that he did.
I mean, you could have owned it if you just made the payments.
That's correct.
Do you mind if we, can I take a break to consult my clients to see if I have anything further?
Sure. It's 1:05, 10 minutes.
Sure.
Okay.
If we understand, yeah.
What y'all think about the Voodoo funds?
Oh my God, what a crazy thing. That's something out of a movie. It's sad, no, it's very sad because
It's
they're
very
gonna
sad.
chop up all those jewels and just sell them as
I
individual.
read like some of the stuff that was taken, unbelievable.
Yeah, no, it's
Hundred something diamonds.
and sapphires, like the purest sapphires. And
Unbelievable. Yeah, and it's the fact that they did it in like broad daylight. But just rolling a ladder truck.
and they
Museum.
escaped on a moped.
Moped. How have they not, they haven't caught him yet.
It's like something in a French movie, actually, like one of those,
Yeah.
So he's saying that it ripped off, but in terms of the agreement, he said Marlon was paying. But in that email, he's agreeing to pay. Right, but of course he did, from other does.
What was this thing? So-
Yeah.
Yeah, I said.
No, okay, that's understood nonsense. So I mentioned that all in hand, I'm now carrying multi-member initial possession. I guess he says, okay,
Yeah,
makes sense.
that's what, this is
a
what,
commit me to do.
that's what we argued for
Yeah, I
the
get it.
motion to compel.
Yeah, yeah.
That's what we argued, that's what we got. And then,
Okay, forget it. You're right. It's not coming along.
yeah, it's not like a slam.
I mean, the thing is, you could eventually impacted the credibility
Of all of us. Wow, so he says it's a cost. He gives them a plot. This is your case.
Still got 2016. We're talking about agreements in 2018. There's nothing wrong to agree in 2016. Nothing.
But that's a landmark moment.
It took like 2 hours to talking about 2016.
Only this place. I don't know. What do you call it? I can't know whether we're stuck in here somewhere. Just my notes from this exam.
We didn't eventually think about building permit.
Yeah.
We looked building permit.
Can't cover everything.
Okay.
I also thought that it was really,
They've been problem.
So,
Oh, yeah,
Thanks.
I forgot that. Is lots of them?
Yeah.
Was he gonna be locked up?
I was gonna try out a little.
I don't know.
Okay, we'll see. I think she said she was gonna see if she had anything.
You didn't take mine, obviously. No. Is this all yours? It's a good. See, I knew it.
Priest, it's almost drives you nuts.
That's what I'm sure. But they have to do, I knew your papers look too good. You need more papers.
No. Good. No, I don't want to write anything from staff. Good.
I was like, I swear I have this. I do this for a reason, too. I have a bunch of newspapers.
Yeah. I'm sorry, Chris.
No, I just throw home, as long as I have this.
Just got the policy.
Yeah. Yeah, I was thinking about that. Cause I think he gets too spinny there, like it's too much stimulus and he's just a little confused.
Please be seated. Okay. Madam Court Reporter, are we back on the record? And Mr. Gunbie, can you hear me?
Yes, I can, Your Honor.
Okay, thank you. Mr. Downs, any additional questions?
I have nothing further at this time.
Okay. Excuse me. I was in the last few minutes going through my notes to see if I had any follow-up questions for Mr. Gunbie. I don't think that I do, so I'm going to let you, if you have any redirect for your client, go ahead, sir.
Just very briefly, Your Honor. Mr. Gunbie, we looked at the agreement. Section 2.3 says that if at any point you wish to cancel the agreement, that no payments are due back to you. Do you recall that section of the agreement?
Yes.
Notwithstanding that, the lack of payments and any argument that the agreement terminated due to non-payment, putting that issue aside, at any point in time, did you wish to cancel the agreement?
No.
Mr. Downs asked you some questions about your immigration status, and about how long you could be at the property, et cetera. Do you recall those questions?
Yes.
Let me ask you this. Is your wife, who is also a resident at the property, is she under any similar immigration restrictions that would require her to leave the property? or leave the country?
No, she's not. She's a green card holder. Therefore, she's a resident alien and not required to leave the country.
Mr. Downs asked you about, he said, Mr. Badham isn't required to give you any notice if you don't make payments for 6 months. Do you recall that question?
Yes.
And we can quibble over what payments were for and what they were not for, but let me ask you this. Would you have expected Mr. Badham to have accepted over $351,000 in payments after the agreement was terminated?
No.
And you recall the email where he is suggesting that you, and I believe that's the word that he used, suggesting that you pay $200,000 so that he could pay off his mortgage. Do you recall that document?
Yes.
And you testified that you didn't transfer $200,000, but you did transfer some large amounts of money shortly thereafter, correct?
That's correct.
From your understanding, if Mr. Badham truly thought that the agreement had been terminated, can you explain why he would have expected you to pay off his mortgage if he thought the agreement had been terminated?
No, I cannot explain that.
Your Honor, that's all the questions I have.
Okay, anything else, Mr. Downs?
No, Your Honor.
Okay. Mr. Gunbie, you are excused as a witness, sir. You, of course, as a party, are free to continue to remain on the line and listen to the proceedings. Mr. Withers, do you have any additional witnesses?
Nothing further. The defense rests.
Okay, any rebuttal from the plaintiffs?
No rebuttal. I would like to make a motion, though, Judge.
Okay. So the evidence is closed, and since there's no rebuttal, and so now if there are post evidence motions, Mr. Downs, please go ahead.
Yeah, I would just like to move for involuntary dismissal, also known as directed verdict on counterclaims.
Go ahead.
I'll try to keep this quick. I know the court's patience is, appreciate the court's patience throughout. We move under OCGA 9-1141 for involuntary dismissal of the counterclaim since it's a bench trial. I don't believe there's been any evidence presented on the breach of contract or specific performance claims. That they have not demonstrated that they complied with the contract. And the contract clearly requires full payment of the purchase price to become the owner. And the Gunbies testified they never paid the full purchase price. So you can't get specific performance if you don't comply with what you need to do to get there. Likewise with the breach of contract claim. Regarding the unjust enrichment claim, I again want to point the court to the Morris versus Britt case that I cited yesterday in response to Mr. Withers. This is 275 Georgia App 293. I think this case is, almost identical to the current one. In this case, the tenants, the plaintiffs, agreed to buy a house under a lease. It was called a lease purchase in this case, but the lease purchase did have an interest component of it. So in this case, they were supposed to pay a total of $65,000. And then they had an option, essentially like a balloon payment, $25,000 plus the accrued interest on or before a certain date. And they didn't do that, but they continued to stay in the property and continued to make the installment payments, which is actually unlike the Gunbies, who never continue to make installment payments afterwards. But they were evicted. A dispossession was filed against them. They did not pay rent to the registry of the courts. They were evicted, unlike here. But as to unjust enrichment, what they claimed was that they were entitled to $101,000 for the work they did on the property with the expectation that they could purchase it. For unjust enrichment to apply, the party conferring the labor and things of value must act with the expectation that the other party will be responsible for the cost. Otherwise, that party, like one who volunteers to pay the debt of another, has no right of equitable recovery. So the court in this case found that it was the tenants who intended to personally benefit from all the repairs and the additions that they were making under this lease purchase. And then notably, the court says, sadly, the Morrises failed to protect their investment in the property by exercising the option to purchase the property or by reaching some separate agreement
What
concerning
about,
the improvements.
if that logic applies to the improvements though, what about the repairs?
They stood to benefit from all of it had they purchased the house.
Well, except that the agreement specifically provides that they would be responsible for repairs. But your argument is without reference to the agreement at all, that all of the repairs and all the improvement were for the benefit.
No, I'm
of the
referencing the
tenants.
context of the agreement, because that's the whole context, is that they had these tenants here had a lease purchase.
Mhm.
Like I said, they're making the improvements with the expectation they were going to buy the property, just like the Gunbies.
Okay.
And so they were making them for their own benefit. They had no expectation that the Badhams were going to reimburse them or pay for any of this stuff. And so, they haven't demonstrated that the Badhams were unjustly enriched in any way. And interestingly, in this case, I didn't remember this last time, but to Mr. Withers was arguing about that this is really a mortgage. This case even addresses like that particular point. It says that because they tried to make that argument because that this is the equivalent of a sale under a mortgage, and the Court of Appeals rejected that. Anyway, so no unjust enrichment, and as to promissory estoppel, with those elements of that claim, first of all, there has to be a promise, right? We haven't even demonstrated a promise. There's a written contract that is the only thing that was promised. There's been no testimony that Mr. Badham, promised that he can continue to buy the house under this agreement. So there's been no documentation of that. Another element of promissory estoppel is justifiable reliance. There's no evidence of justifiable reliance in the face of an expired agreement that they didn't make payments like for 6 months. The agreement expired, and even after the agreement terminated, there's subsequent agreements presented to them, like, hey, let's come to new terms, and no agreement. So how can you justifiably rely on that 2018 agreement when there's simply no reference to it anywhere?
Can the subsequent allowances of the Gunbies to remain in the house after the agreement had by its own terms ended, can the ongoing communications, which while I generally agree with you, they demonstrate there's not a clear understanding of any terms or a formal agreement, I think there's maybe an argument to be made that they indicate some acknowledgement by Mr. Badham that he still intends to go forward with some transfer of ownership. We just still have to renegotiate what those terms are. So could those communications and his acceptance of payments, even though the payment amounts are disputed, ongoing after the agreement, constitute an actionable promise for purposes of promissory estoppel?
Well, interestingly, Your Honor, to that point, you cannot claim promissory estoppel when there's a promise that's, quote, vague, indefinite, or of uncertain duration. And this is from, what's this case? The 280 Georgia App 406. It's a 2006 case.
I'm sorry, 280 Georgia.
Georgia App 406.
Thank you.
I'll come up with the name of it in a minute here.
The
It's
site's more important, but
Yeah, Mariner Healthcare versus Foster. Sometimes I miswrite down the site, so I need the name. But in that case, I mean, it was a very similar case as well. there was a lease that the tenants had that had expired, but they continued to remain in the property.
Is that the one with multiple, it was like nursing home and multiple properties? I think I saw one of those when I was doing some research last night. But if not,
I think it is. Yeah. Yeah, in that case, they continue to occupy. They even increased the rent, and they were trying to negotiate for a new lease. But then, the negotiations were, they weren't definite, right? They were just negotiations. And so the court said, you can't claim promissory estoppel when there's a promise that's too vague, indefinite, or uncertain. And similar to like the concept of statute of frauds, right? I mean, you have to. This is real property. We're talking about. It has to be something concrete in writing, something that we can rely on. And you can't claim promissory estoppel over a 2018 agreement that you could just continue in perpetuity.
well, I understand that potentially. I guess my question though is the ongoing behavior by Mr. Badham that if interpreted in a certain way could indicate that he had an expectation that eventually under some terms that had not been agreed on and are not maybe the terms of the PSA, right? That a sale would eventually occur. And so my question is, can that constitute a new promise or subsequent promise independent of the promissory, the purchase and sale agreement?
No, it can't. I mean, it has to be certain. It has to be definite. Like there has to be some sort of definite promise, right? It can't just be like, oh, we were just continuing the course of conduct. It can't be that. It has to be, what is the promise? It has to be like objective, in other words. And we just don't have that here. So for those reasons, we would move for involuntary dismissal of all the counterclaims.
And the claims are breach of contract, specific performance, unjust enrichment, promissory estoppel?
Those are the four that I think are still in play.
Right.
Yeah.
That's what my understanding is as well. I just wanted to make sure.
Yeah.
Okay. Mr. Withers?
Thank you, Your Honor. I said at the beginning, this case is messy. And people don't like to hire lawyers. I get it. But this is what happens when you don't do it. You end up in a situation like this. And it's unfortunate, but, I commend Mr. Downs. He's done a great job. I've enjoyed working with him. He's very professional. But I obviously oppose motion for directed verdict or involuntary dismissal. I mean, what the evidence has shown is that there was no written lease agreement, no rental contract, nothing. And the Gunbies made payments and the Gunbies made improvements, and we can argue about what the legal effect of failure to make payments was, but my position, and as I'm sure the court is well aware, a party can waive a breach by the acceptance of continued performance. You can call it a mutual departure. I've seen cases call it a quasi new agreement, but that can happen. And if we assume that the purchase and sale agreement terminated due to missed payments, Mr. Badham continued to accept payments towards the purchase of the house. In fact, if we look at, the court need look no further than Plaintiff's Exhibit 3. As I understand the parties' intentions here when they entered into this, it was essentially, you pay us $450,000 according to this schedule. And if you don't, then absent some other acceptance of performance or revival or whatever, the agreement goes away. You no longer have the right to purchase the property, but if that happens, you no longer have the obligation to pay for the property either. It's not like Mr. Badham loaned him $450,000 or $502,000, whatever it is, and then Mr. Gunbie continued to pay that back to him. It was, hey, we have an amount here, and we're just going to chop down that amount with every payment. So if the agreement terminates, there's you no longer have a right to buy the property, but you still no longer have an obligation to pay for it.
Right, but you don't get to stay in possession of a piece of property without paying something for it.
I understand that.
Okay.
But if we look at Plaintiff's Exhibit 3, as of January 22, which is roughly 2 or 3 years after Mr. Badham contends that the agreement terminated, he still has on the books $639,000 that he contends is owed. And, some portion of that is the $450,000 purchase price. You cannot, on the one hand, say you have no right to purchase the property anymore, but you still owe me the purchase price. Those are inconsistent positions to take. The only way you can have, in January of 2022, $639,000 left on the deal is if you can say that the rent and the utilities and the rent, the interest, and the flex payment totals $630,000, and there's no evidence of that. That's just simply not there. So I certainly take the position that in this case, by continuing to accept payments, accept the benefit, you can't, any claim that the Gunbies breached the contract goes away, and that contract is still in force. During our closing submissions, be glad to cite some additional case law to that, but I don't think the evidence supports clearly, at least without the benefit of closing arguments in briefs, I don't think that the evidence supports the notion unequivocally that Mr. Badham didn't waive that breach or that alleged breach. As to specific performance, it's an equitable remedy that compels a party to honor the terms of a commitment where there's no adequate remedy at law. And that's Clayton versus Deverell, 257, Georgia, 653. And as I know the court is aware, specific performance, real estate related cases.
Of course.
That's where it
real
happens.
estate is unique. I certainly understand that. I think what I'm struggling with from a specific performance perspective is, generally speaking, the party who seeks to enforce the specific terms of the contract isn't supposed to also be in breach. And I understand that your argument would be, well, but any breaches they had been waived. But doesn't that put us in this sort of impossible situation where just because Mr. Badham continued to talk about selling him the house for a period of time, that now Mr. Gunbie can just forever into the future elect to purchase the property and Mr. Badham can't say no?
Well, I think that would have had to make that clear, okay? And those cases that deal with waiver and mutual departure and quasi-new agreement, there's also the concept that you have to demand strict performance. Mm-hmm. And you have to, once you've departed, you have to put the other party on notice that, hey, from this point forward, I expect you to strictly comply with the terms of the agreement. And that didn't happen. And that's but
that didn't happen either way, right? Not only did Mr. Badham not say, hey, you haven't been paying me, you've got to pay me, but at no time did anybody point me to Mr. Gunbie in writing saying, hey, you still have to sell me this house. I'm continuing to pay. I expect to still be able to buy the house.
I understand, and that's fair. My client wasn't trying to terminate an agreement. Okay, my client was operating under the good faith belief that that agreement was still in force, as reflected by the fact that payments were continuing to be accepted, and by the fact that in January of 2022, Mr. Badham still had the purchase price on the books as an amount still owed as of that time. I believe, and if we were talking about, for a jury, question of fact as to that issue, but, because it is, real estate is unique, and once the court considers all the factors, that, we believe that is still, an appropriate remedy. As to promissory estoppel, promises can be made verbally, they can be made in writing, and, people can communicate their intention by actions. They continued to accept the payments, and I think my client relied on that. And the fact, as to what the purchase price was, and then again, this document, he still got it on the books. So he understood that was, my clients were relying on that. And I just think it would be incredibly unjust to say, I continue to accept all these payments, I get to put them in my pocket, and you get nothing, and I didn't have to tell you that, the court is right. At any point, Mr. Gunbie could have said, well, hey, I believe we still have the agreement in place. And that's a fair criticism. But by the same token, at some point, Mr. Badham could have said, well, why are you continuing to send me these payments? You don't have any right to purchase the property anymore. There's no evidence that the total amount owed was outside the value of the property, was $600,000 in January of 2022. I do think promissory estoppel is something that the court can award here, or at least should consider, closing arguments on that issue. Obviously the unjust enrichment claim is an alternative claim. If the court were to find that there was no written agreement, or that the PSA had not been revived through continued performance and acceptance of benefits, my clients have conveyed an appreciable benefit on the property. There was no, it's kind of one of those things where at the time they made it, they absolutely believed that they were entitled to purchase the property. And that's the only reason Mr. Gunbie testified. I wouldn't have made these payments, I wouldn't have made these expenditures had it been communicated to me that, hey, you no longer have this right. What my clients expected was not, reimbursement as far as compensation. What they expected was that they would be able to retain the property, and, retention of these benefits by the Badhams, I submit respectfully, would be grossly unjust, given that, my clients made these improvements, these investments in the property under the extremely good faith belief that the deal was still effective. Again, you can't say you still owe me this money if you, and at the same time take the position that I have no obligation to convey the property. So I think unjust enrichment is, an available remedy if the court finds, for whatever reason, that the purchase and sale agreement was terminated. And I would certainly appreciate the opportunity to expound upon that further in brief. But I do believe that, at least at this stage, there is sufficient evidence that supports all of these claims. Now, whether the court ultimately, considers the facts and the evidence and makes a determination on those after, proper review, that's another matter. That's why we're having the bench trial, right? And so, but for those reasons, we respectfully submit that the plaintiff's motion for involuntary dismissal of directed verdict should be denied, at least at this time.
I have one question for
Yes,
you
ma'am.
before
Yes,
I
ma'am.
hear from Mr. Downs. If, let's say that the court were persuaded that there are fact issues here that need to, that survive a directed verdict, specifically on promissory estoppel and unjust enrichment, but perhaps not on the contract claims, does that automatically entitle the Badhams to a writ of possession?
I'm sorry, can you repeat the question?
Yes. So there are 4 potential causes of action here that have been asserted in the counterclaim. And Mr. Downs has moved for DB on all of them. But I guess my question is, if the court, 2 of them, to my way of thinking, are contract theories, a contract remedy and a contract theory, right? Breach and specific performance. And 2 of them are theories of obligation that are outside of a contractual relationship, right?
Equitable. Yes.
Equitable. And so my question is, if I were to grant the directed verdict as to the contract claims, the specific performance and the breach of contract, because, for instance, the court were not persuaded that this contract continued after June of 2021, does that automatically entitle the Badhams to possession of the property, regardless of any survival and potential success of a claim by the Gunbies to promissory estoppel and unjust enrichment damages? Does that make sense? I'm not sure I said it better the
No,
second time.
it does. I think I understand the court's question. I don't know the answer.
Okay. I don't either. That's why I asked the question. So
I would need to research that question. And I would give you an answer if I had one. I just don't. But again, I would say, that our position is, and happy to get some specific law on this, but that, a breach of contract can be waived by, continued acceptance of benefits. And we believe that's exactly what happened in this case. So does that?
it does.
Okay.
I mean, no, I think that's a fair way to respond. I don't know the answer either. To be sure, regardless of any ruling I make at this moment, I don't intend to issue a writ of possession today. I do expect to hear from the parties about how and under what circumstances, if the court is inclined to issue one, it would be done and on what basis. But that is just a question that I would like answered from the parties in terms of because let's not forget, right, that what started all of this procedurally was the Badhams' effort to repossess, to dispossess the Gunbies and to repossess their home. And so what they have asked for is a writ of possession. And so my question was, to the extent that I have denied your motion for directed verdict on their motion on their writ of possession. And so I guess that was just playing it out from a larger perspective. How it's postured procedurally is, does the court's ruling on any or all of the DD motions for the 4 counts, is it outcome determinative of the dispossession? And that's really just a broader question that I'd like for y'all to think about in terms of how it affects the court's ruling today or after today on the actual bench trial instead of a DB.
Yes, ma'am. And I'll be happy to research that and give you the best answer I can. I'm not in a position to do that today.
Yep, I think that's fair. I've looked and I haven't found the answer yet either. So, or at least a nice, well laid out one that I definitely think is right. I understand. So thank you, Mr. Withers.
Thank you, Your Honor.
Mr. Downs, did you have a rebuttal on your motion, sir?
I didn't, Judge. I just wanted to jump in on y'all's discussion about that. The way I think about a promissory estoppel claim, again, I haven't researched either, but it seems like an equitable claim. And so if the court were to, I think it would be inconsistent to grant a writ of possession, but leave grant a writ of possession as to leave the promissory estoppel claim open. Does that make sense? I mean, in other words, like the court, you have to deny their, either through this motion or, the final judgment
Mm-hmm.
in order for the Badhams to get a writ of possession.
Right. Okay.
Is that your?
I think I understand your point, and I think that's fair.
Yeah. It's a contract claim. I mean, it's like,
Right.
it would be unjust to not enforce this promise.
Right.
This contractual promise. And that's why I made the motion, right? Because, this is real estate. I mean, we need to have something concrete
Mm-hmm.
that will satisfy the statute of frauds to get to a promissory, like estoppel claim, right?
Mhm.
And we don't have anything close. I mean, I specifically asked, Mr. Gunbie about the term, and he said he could just pay whenever. I mean, that's too vague.
Well, respectfully, he didn't actually say that. You asked him that question, and I explained to him that I understood what you were implying from it, and then we moved on.
Well, there's
So-
no time frame for him to make the payment. That's the
right.
point.
That's clear.
And that's too vague to enforce a promise.
Mhm.
And that's why we made the motion.
Okay. So I do have one question for you guys before, regarding the contract claims, right? So this is maybe one of those situations where the judge is overthinking the facts because y'all know more about it than I do. But, the actual agreement that y'all are asking me to decide whether it's an agreement, whether it's still in effect, whether it terminated, whatever, it's between Mr. Badham and Mr. Gunbie. And it identifies Mr. Badham as the sole owner of the property when in fact he wasn't. He was a joint owner with right of survivorship, in fact, with his wife. And so let me say this. I am aware that there's case law that says that I could go enter into a contract with you tomorrow to sell you Mr. Downs' house if I have a reasonable belief that I can purchase and obtain Mr. Downs' house to be able to sell to you by the time we have to do it. But not for nothing, it's a little odd that these two gentlemen were engaging in this agreement. And also not for nothing, maybe I'm biased because I'm a female, but I am very frustrated and disappointed and upset with these two very sophisticated, very intelligent, very knowledgeable businessmen who, I understand friendships and I get that, but this, as both Mr. Badham and Mr. Gunbie acknowledged, this would not be messy if they had made any sort of reasonable effort to properly document the nature of their agreement and what payments were being made relative to what. And so I'm a little frustrated by that, but that's, if it wasn't that messy, then y'all wouldn't need me to solve this problem, I guess, so.
And neither Mr. Downs nor I, will we be selling shoes.
So let me say this. I definitely think that there is enough for me to get to deny a directed verdict motion on the equitable claims that have been asserted, right, for unjust enrichment and promissory estoppel. The reason I asked you about the contract and the fact that it was actually only entered into, I don't know that it makes it invalid, but I mean, it further, to me, knocks out another one of the legs of this stool of this effort to sell when all it is an agreement to agree. Now, it's got enough meat on it that we are imbuing it with the full sense of a contract. But when you further undercut it by the fact that Mr. Badham was agreeing to sell something as the sole owner when in fact he wasn't, it's all messy. In any event, so I'm definitely going to have you guys submit closing arguments to me because I'm going to deny the motion for directed verdict on the unjust enrichment claims and the promissory estoppel claims. I understand the Gunbie's argument regarding the contract and the parties, as I was pointing out to you and to Mr. Downs, the communication between Mr. Badham and Mr. Gunbie is both demonstrative of a continued ongoing relationship and expectation that the ultimate end goal of that contract in 2018 or that agreement to agree was still on the horizon,
but it is also evidence of a rejection of that original agreement, and we need to discuss new terms because he's saying, hey, give me this money to pay off the mortgage, or let's add 52,000 to it and renegotiate. And then later he's like, now it's 700 and something. Let's agree to sell. And so I don't know that there is anything from which I could find that the May 18th agreement continued in effect. And that is despite what I think is fairly undisputed evidence about the failure of payments by Mr. Gunbie, the failure to make the balloon payment by Mr. Gunbie, but also, as you correctly point out, the failure of Mr. Badham to say, you're in default and I'm not selling you my house. But I think that the undisputed, as much as the parties wish to recharacterize or put their own spin on what the facts are largely not disputed here. And so based on those facts, I don't know that there is a basis for the court to find that the May 18th agreement continued in effect. And so because of that, I don't know that there is a basis for the breach of contract claim to go forward. And I also don't believe that there is a basis for the Gunbies to seek specific performance of that contract, if in fact it ended by its own terms in 2021, despite the Gunbies' argument that perhaps because of continued performance by the parties and a lack of notice of default, that it might have continued. It didn't continue infinitely into the future. And so I'm going to grant the Badham's motion for directed verdict as to the count for a specific performance and the count for breach of contract, and ask you guys for arguments on the promissory estoppel and unjust enrichment. Because at the end of the day, and I'm done with my ruling, and I'm just telling you, what my thought process is as I'm processing the evidence that I've heard. The frustrating part here is one of the reasons I asked the question about the writ of possession is that there is a deed, right? There is an official record of the property of Fulton County, and it says that the Badhams own that house. And so what I'm trying to figure out, conversely, is whether it was because the Gunbies thought they personally would benefit from it because they were going to subsequently purchase the house or not. There's also there's really not a dispute here that the Gunbies made very valuable improvements to the property and that they spent a great deal, that despite what's the word I'm looking for? Despite the sporadic payments, overall, and despite the fact that it's difficult for the court to account for what those payments were for in some instances, I don't think there's really a dispute that several $100,000 at least by the Gunbies were paid to the Badhams, and that amount exceeds what would have been reasonable rental. And so those are the parts that I have to figure out in terms of what to do with a promissory estoppel and what to do with unjust enrichment. And so that's what I have to figure out. But that's what I'm going to do, and I ask that you guys, in terms of the arguments that you are going to make, obviously, I'd like for you, as you have done somewhat now, point me to case law regarding the ability of promissory estoppel to be actionable here. I know Mr. Downs had already tried to direct me to that one case that says, if you did it for your own benefit, then it's not promissory estoppel or unjust enrichment. So I would like that information. I also, based on the evidence that has been presented, I think if you'll recall, I mentioned to y'all that one thing that is helpful to me is understanding if there are money damages or if there is value contribution, right, that I need to be accounting for. Help me figure out what it is, right? Because, so for example, I've got repairs that may be pursuant to the contract that the Gunbies made with no expectation of repayment, but still inure to the benefit of the Badhams if they retake possession of the house. I've got improvements that Mr. Gunbie, I think, acknowledged that he did not ask for permission and didn't
and thought was being done for the benefit of the house, right? That he expected to continue to own. And so to the extent that you can help me with those things, I mean, I've got those numbers and I've got 437,100 and something dollars, which I think the undisputed evidence, or at least the evidence I've heard, is we all concede is less than the purchase price that was agreed upon, but it might be even less than that because maybe some or all of it wasn't intended to be compensation for the house itself. And so if you guys can direct me to those aspects, I think that would be very helpful for me in figuring out where this goes. As I mentioned, ultimately, the final judgment that I enter will be whether or not the Badhams are entitled to a writ of possession, and then whether or not the Gunbies are entitled to recovery of any kind in any manner on their unjust enrichment and promissory estoppel claims. And so one way, and I think Mr. Downs, in answering my question that I was asking about the effect of denying the contract claim, I think that the reason I asked that question is that certainly one outcome is that if I am persuaded that returning the house to the Badhams in the context of the contributions that have been made and the expectations, et cetera, would be fundamentally unjust, right? Then that's one outcome. One outcome is that the Badhams are entitled to have their home back, but if the Gunbies are entitled to some sort of relief on those claims that doesn't entitle them to possession, does it entitle them to some sort of equitable lien as a remedy for the promissory estoppel or the unjust enrichment, if that's what the court finds? So that's the knot that I would like for y'all to help me untangle, if that is helpful at all.
Yes, Your Honor.
Anything else from the parties before we adjourn for the day? Mr. Downs.
Yeah, I do. Just, you want proposed, I know you want closing arguments.
Mm-hmm.
At this point, do you also want the proposed verdict?
I do.
Okay.
Okay. And I assume, and it's because, I mean, if I were to do a judgment and verdict form right now, it would say, plaintiff's claim for writ of possession, right? I find in favor of the plaintiff or find in favor of the defendant. And then I would say counterclaim, whatever. But the difference here is that their claim for a writ of possession is I give them one or I don't. They get the house back or they don't. The potential remedies available to the Gunbies, even if I give a writ of possession to the Badhams, are more open. And so I would be, obviously Mr. Withers has a reason to argue, one, that they should still get to keep the house, but if they don't, that they're entitled to something. I'd be curious to know what the Badhams' position is in terms of if we get the house back, if the court finds any unjust enrichment or promissory estoppel, are the Badhams willing to do the facts bear out any entitlement by the Gunbies of any kind? And I understand legally right now from your DB argument, your position is no, because the promissory estoppel is not actionable, et cetera, because of the lack of clear terms and that sort of thing. But does that help answer your question?
And the only thing to that point is that, I mentioned this earlier in opening, but, because we have a rent order into court, we, after now Your Honor's heard all the evidence.
Yes, sir.
Since we're not asking for money as relief in the case, we would ask.
Except for attorney's fees.
Attorney's fees, yeah, right, not damages, but attorney's fees. Based on the dispossessory law, like if we win, let's say we win writ of possession, right? They can appeal without paying any money to the court, right? They just have to keep paying whatever the state court has already ordered to be paid. We just want that order modified to reflect fair market value of the rental. So should I submit a proposed order on that, and also to that would be a final judgment, but I just wanted to state that for the record, and then also to get an order for the existing money that's in the Superior.
Okay. Well, definitely I need an order, if you want me to enter an order authorizing you to remove funds from the registry. If I need to sign such a thing, send it to me and I will. Regarding the argument about, I think your assessment of what's allowed or entitled is correct. I think that what would need to happen is if and when, right now, that order continues in full force and effect until I enter an order otherwise. If I were to enter an order granting a writ of possession to the Badhams and a timely notice of appeal were to be filed, then that notice of appeal operates as supersedious even in a dispossessory action unless the parties ask, right? And so I think procedurally what I would be expecting is at that time for such a motion to be made saying the current order is insufficient to operate as supersedious in the dispossessory.
That's fine, yeah.
Okay.
Timing, Your Honor.
So I mentioned that I don't want it to get stale, right? Because like I'm supposed to start a criminal trial on Monday or maybe a civil trial if they don't tell me that they've settled this case by today. So I don't want it to get too far out because then I will lose, I've got lots of notes, but I don't want to lose the presence of mind of, my read on the facts of the case. And so I think originally I had mentioned 5 days. It's Friday, so I would not say I have to have it by next Friday, but perhaps the Monday after that, which I think is November the 3rd. Is that right? Let me look at it.
It is.
Okay. If that would be doable for the closing arguments. And again, I also would like to, I don't want to be overly limiting because it is a closing argument. Lord knows we lawyers can all talk, but I don't want you to write me a treatise, right? 10 pages? Is that unreasonable, not unreasonable, Mr. Downs?
That's plenty.
Okay. So I will ask.
Single space, right?
That's fully what I was expecting is a letter brief that's 10 pages, single space. Yes, by Monday, November the 3rd. You can, and if you would please try not to exceed 10 pages, I would appreciate it. Any other questions regarding the logistics of that?
Yes, should we, since they are closing arguments, should we e-file those into the docket?
That's entirely up to y'all. You don't have to, but my guess is that you'll want to because you'll want the Court of Appeals to have a fulsome understanding of what you argued to the court. And so you're free to file them, but understand that just like anything else, if you file it, I don't get it. So you have to email me a copy if you want me to read it, because we don't get notices when things are filed. You have to send me a courtesy copy.
I wonder if there's a category for closing argument.
There's probably not. I think it's going to be other.
Other or notice?
Yes. So.
Okay,
Okay.
all right.
Thank you all very much.
All right, thank you.
Have a good